High Court, Division Bench or Single Bench was stayed, the Honorable Supreme Court was pleased to, my lord, stay the contempt proceedings. That is again, my lord, subject to correction. Because, my lord, these other all ancillary matters, I am not there. But to my knowledge, my lord, I have not seen any order staying the Division Bench's order on merits. The contempt proceedings has been stopped.
My lord, if I get, my lord, few minutes time, my lord, subject to, my lord, kindly allow me, my lord. The contempt proceedings, my lord, has been stayed in Binapani Murmu matter, my lord, by the Honorable Supreme Court, my lord. I have mentioned, my lord, a chart, my lord, for that reason, my lord, I have to make understand, my lord, for myself also, my lord, I have made a chart. My lord, if your lordship kindly sees second page of the chart, it is, my lord, C, my lord, Binapani Murmu. My lord, your lordship, my lord, kindly see, my lord, in the Binapani Murmu matter, my lord, the Honorable Justice Kaushik Chandra, my lord, allowed the writ petition, my lord, because, my lord, in this, his lordship, my lord, has stressed that in the statute there is a provision.
Sir, please show us the list. Where you are showing, please show us.
Page 2 of the.
We have asked you 3 times that, sir, please show us whether in a similar matter the parent order has been stayed or the contempt proceedings have
Contempt proceedings, my lord, has been stayed.
So then no, the order was not stayed.
My lord,
in similar matter, whether the order of the single judge, similar order was stayed, yes or no?
My lord, my lord, the contempt proceedings has been stayed. Contempt proceedings, my lord, has been stayed, my lord.
Then from the morning, why you are saying that there is stay, come to the chart, see the order?
My lord, I am saying, my lord, because of the compassionate appointment.
Sir, please tell us where is the stay order?
Compassionate, my lord, kindly bear with me, my lord, for few seconds, my lord. For compassionate.
Go and study. You first understand, then tell us. Adjourn for a month. Yes.
My lord, kindly do not, my lord.
Simple question you cannot.
My lord, kindly excuse me, my lord. Kindly do not, my lord. Kindly see, my lord. The two, my lord, of compassionate appointment has been stayed, my lord, in a Mithuna church matter, my lord. That I wanted to see, my lord. And in the similar type order, my lord.
Sit down. Sit down. Have you filed any contempt petition?
Yes, sir. Contempt petition is pending.
ওকে দাও ওকে দাও 3টে কপি ওকে দাও in which order the order has been stayed? in মিঠুন আচার্য order stay করেছে না ডিসমিস করলাম দি গ্রাউন্ড অফ ডিলে সেখানে রিভিজিট করতে বললো রিভিজিটেশনটা স্টে করে এটা তো প্যাটার্ন ডিসিশন না
May I?
Sir, we are already confused. Please.
No, I understand. I understand.
My lord, on
who is your senior, Mr. De?
Mr. Ganguly, my lord.
Ganguly means which?
Somnath Ganguly.
Uh-huh.
Mr. Somnath Ganguly.
Where is he?
He perhaps, my lord, has not come, my lord.
Huh?
He has not come yet, my lord.
We are passing the same order which we have passed in the case of Pritam Mollik.
Yes, ma'am.
Will that suffice?
Yes, my lord.
In Pritam Mollik, we stayed the contempt proceeding.
Yes,
We
ma'am.
did not stay the order. Yes.
My lord.
So you are satisfied that there is no, in none of the similar matters, the parent order of the single judge has been stayed. Don't think of Mithunacharya, because Mithunacharya was dismissed on the ground of delay.
Yes.
In the appeal, Justice Talukdar said revisit. That the Supreme Court has stayed.
Yes, my lord.
That the Supreme Court has stayed.
Yes, ma'am.
But the parent, in the other matters, that is in the name Pritam Mollik, and second page Binapani, third
Yes.
page Priya Haldar,
Yes.
Priya Haldar, in these three cases, there is a stay on the impugned order?
My lord, my understanding is that the Supreme Court is in active consideration of those cases.
That is pertaining to stay of the contempt proceedings.
Stay of the contempt, my lord, notice has been issued. Notice has been issued and affidavit is being exchanged.
Lord, my lord, kindly give me 1 minute.
Yes. Where is Somnath Ganguly?
Mr. Ganguly, my lord.
It will be there tomorrow. Ask Mr. Ganguly to be here.
Yes, my lord.
Come tomorrow.
My lord, kindly keep this judgment, order, my lord, in the.
Please keep it with you. Tomorrow you give it to us. Come tomorrow.
My lord.
Led by Mr. Rahul.
Mr. Pal, where is here? দাও পরেরটা দাও। Where is Mr. De? Give a phone call to Mr. Somnath Ganguly. Is he in court? If he has come,
I have to check, my lord.
you check it up, Mr. Pal. Wait outside. If Somnath Ganguly is there, we will take up the matter.
Yes.
Pass over. এক নম্বরটা পাসওয়ার্ড করে রাখ। আর ওই নীলত, if it is taken up, then tell Mr. Nilotpal Mukherjee. Please tell the advocate who appeared, Nilotpal Chatterjee.
It is for the appellant, my lord. It is that single subject teacher willing, similar order I'm praying before, covered by lordship's judgment, my lord.
I'm praying short passover. Mr. Roy is engaged another court lordship. I'm praying short passover lordship. He's engaged another court.
Who?
Mr. Roy. He's for commission.
For commission. We passed similar order in his presence. Has he come to court? So where is he?
Another court lordship engaged.
Call him. Ask him to come. Pass over.
Yes. অর্ডার গুলো দিয়ে দিলাম তো, অর্ডারটা থাক। আচ্ছা ঠিক আছে, অর্ডার গুলো তো সেম।
He also
I'm-
is appearing for
Similar matter.
You know, you are
I'm the state,
state, and he is for whom?
Commission. Mr. Roy is for school service commission.
Roy means junior to Dr. Patro.
Yes, Mr. Sunit Roy.
So he will again come and say adjourn the matter because Dr. Patro is
No,
not.
no.
এটাতে আনবে
He is independently appearing.
যাক বাবা বাঁচা গেছে ডেকে আনো
দেখো না যদি পাও খুঁজে পাও।
পাস ওভার
Similar matters.
টেক রেস্ট ইউ কেম ওয়াকিং অর বাই কার
পরেরটাও তাই। এটা হচ্ছে সুনিতা আছে।
I'm for the state led by Mr. Shopon Banerjee.
আচ্ছা প্লিজ পাস ওভার ইফ হি ইজ দেয়ার উই উইল
How many more similar?
3 only.
Only three.
Only 3 for today.
ইয়েস কল দি নেক্সট
Lordship, Mr. Joyanta Samanta for the state. He engaged code number 1. Kindly note this week.
State. Five.
Five.
Five now. No, two now.
Joyanta Samanta.
Senior.
Mr. Sen is appearing for the five, Lordship.
Five melody, that matter melody.
ইজ ফর দি অ্যাপেলেন্ট
Melody senior.
ইজ দ্য সিনিয়র অ্যাপেলেন্ট
Yes, my lord.
That was concluded under melody master CAB by the Honorable Justice Harish Tandon sitting with the Honorable Justice Uday.
Well, earlier,
Last occasion,
last time,
of the
it fell from your lordship that it has to be ascertained. What can be done? My lord can take them.
let it be placed before the Honorable Chief Justice for
I do not know the procedure. I cannot say, but I think, my lord,
as your lordship.
my lord,
Mr. Jana, for that, this is now the regular bench.
this is the regular bench.
The difficulty is that both of you agree that it was substantially hard and hearing concluded. So you make a prayer for assignment. Is there any এখানে কোনো assignment order আছে? নেই তো. So both of you, if you want that this was almost concluded by Justice Tandon,
Division bench presided by Justice Tandon.
sitting with Justice Partho Sen.
Justice Partho Sen.
So if both of you make a joint prayer,
Yes.
in view of such circumstances, can it be placed before a bench?
I think that
in
would be
which
the,
Mr.
my-
Sen will be a party.
my lord, my lord. That would,
Or if that is not done, we will
that will be the best course, I think, my lord, what suggested by.
issue
My lord, issue is that, my lord, that special bench in 2013.
Proceed with this case.
Abhijit Vaidya.
Yes, there, my lord, the order passed that the pension should be started from the date of refund of the employer's share of provident fund, irrespective of the date of retirement. Suppose date of retirement 2009, but the refund followed by judgment in 2014, then the pension should be started from 2014, not from 2009, the date of retirement. After so many years, when the pension payment, my lord, disbursed from that particular date of their particular refund of each and every, my lord, the teacher, since 2014 to 2019, my lord, another, my lord, issue cropped up, and again special bench formed comprising 3 judges. This time, my lord, in 2019, special bench said that no, the entitlement to pension should be from the date of retirement, irrespective of the now reverse from the date of refund. So whatever be the date of retirement, suppose 2009, but the refund started in 2014 after refund of the employer's share. So 2009 or 2008 or 2007 to till that date of 2014, the arrear pension should be paid. Now, after this judgment of 2019, my lord, what happened? During this interregnum period from 2013 or 14 to 2019, my lord, several, my lord, independent writ petitions filed in an individual manner by the retired teachers, who said that our arrear pension be paid before the learned single judge. Now, 2 or 3 matters first disposed of, that special bench is there. 2 or 3 matters said arrear pension be paid. Eventually, the judgment said that yes, arrear pension be paid. But neither in 2013 special bench nor in 2014 special bench lordship, there was no whisper with regard to interest on that area sum. Rather, in 2019, the court said that the read petitioners, they themselves said, or they agreed that they do not want interest for that period. Despite being the said fact, my lord, a read petition moved after 2019 special bench order, and my lord Justice Mantha said, clubbing all those my lord, the read petitions which were pending before 2019 special bench, which was filed after 2019 special bench, more than 100 read petitions clubbed, and my lord, by a common judgment, my lord, all those read petitions disposed of, directing to pay interest from the period of 2019 special bench order till the date of disbursement in respect of that area sum. Now, we preferred his appeal, my lord, on a specific point that when special bench neither in 2013 nor in 2019 directed for interest, then whether a single judge can modify the order of the special bench directing the
Court
pension.
is not modifying. Court is saying that 2019, their entitlement crystallized in 2019 in
19.
view of the second judgment.
My lord.
Now, government, in spite of doing that, have not disbursed the money to the pension holders. That is why I think the interest has been imposed.
Interest imposed. Interest imposed
Mr.
from the
Sen,
order passed into from the date of 2019.
2019, the law was declared that
Yes.
your entitlement will be from the date of retirement. Or
Yes.
so from the date of retirement till today,
From the date of retirement till the date of disbursement in terms of 2013 order.
right, till the
So about 3 or 4 years.
you pay that area to the person.
Pay the area.
Now that order was special bench order was 2019.
Yes, and special.
So it was incumbent upon the state to extend those similar benefit to all. Then
Yes. There was no difficulty. Thereafter, what happened, my
but
lord?
there is a delay. He has now come and saying that the
Now, but lordship, in the special bench judgment, my lord, there was no, my lord, no order with regard to interest. Because on the contrary, it has been specifically
I am
mentioned.
wanting to learn, Mr. Sen, that
Right.
2019 the government decision was we will follow the special bench order.
Yes.
So if the government decision should was taken that to all the pension holders, whoever has refunded, got everything.
It
Government
was a
should-
judgment in rem. Yes.
That I think Justice Mantha has gone on that issue.
No, another point was there. All those, my lord, another point
This
was
is
there.
the only issue.
Another
Only
issue.
issue.
Another
This is
issue.
the
No,
only
no. This is not
So
the
what
only
is
issue.
the another issue?
Another issue is all those writ petitioners, more than 100, they, my lord, they preferred individual writ petitions either before 2019
Sir,
special
Mr.
bench.
Sen, we understand the
Madam,
problem.
may I
Now,
tell?
please tell us.
Another
whether
issue
you
is
will-
there.
Acha, we will listen. Will you, are you agreeing with Mr. Jana that you will make an application to the?
Oh, yes.
Tahole we can.
My-
Then we are sending the matter out of the list for the
My-
present. If assignment is granted to any bench constituted with Partho Sen, we will hear that bench will hear. Otherwise, we will hear.
or the regular bench.
We have no problem in
My lord.
hearing.
And my lord, res
But according to
judicata point is also
direction,
involved there.
according to the direction, my lord, the marked as CAB can be heard
No.
by the regular bench. There was no direction.
It has to come to the
Either
regular bench.
retirement or death or my lord, transfer, my lord, that is the
Retirement, death, and transfer.
transfer. So my lord, this can be done, can be heard by this regular bench.
No, we have the determination. Regular bench. Your problem is that we have already devoted much of our hearing before a bench.
No, I have
No.
no problem.
We have also no problem. We never said that. We have also no problem. We want to hear out this matter before your lordship.
Any paper book হয়েছে কি? Is there any paper book?
Paper book কি file?
How many matters are there?
Only one.
একটা? Mr. Sen said that many matters.
Combined
No.
judgment has been delivered.
Judgment, a combined judgment
Judgment.
delivered.
One appeal.
Then, my lord, again one issue just after when the my lord
আচ্ছা
argument.
দেখি এবার ফাইলটা দাও।
when I, my lord, finished the argument, also another, my lord, question failed from the court that whether one, my lord, the appeal. না না দেখে নিচ্ছে একবার দেখে নিচ্ছে my lord can fix it any day, lordship, my lord's convenient day. ওয়েদার আচ্ছা শুক্রবার নয় কিন্তু ওয়েদার নিয়ে তোমার কি মাথা খারাপ করে
করে দেওয়ার পর আর ইচ্ছে করছে না।
হাইকোর্টে গাড়ি রাখছে
শুক্রবার হলে বুঝতাম
prepared a paper book extended learned.
but I think, lordship, all the papers are annexed to this petition. তাই তো এই বলো না
দেখি
এটা আছে
একটাই ম্যাটার তো
একটা কি অর্ডার হয়েছে দেখছি
for the 100 matters which were disposed of, this is one, this matter is included within that judgment.
yes first matter.
No, this Swapon Kumar Chakraborty,
Yes, Swapon Kumar Chakraborty was one of those
one of
those read
so you are
petitions.
challenging 15th of April 2020.
My lord, thereby whereby all those read petitions were disposed of by an analogous as an
So
analogous.
you have to file separate appeals.
No, my lord. I think, my lord, this question, my lord, came up before the earlier bench also. After almost, my lord, conclusion of the hearing, said Mr. Sen, how you filed one appeal against so many. My lord, there is a latest judgment. My lord, I have, my lord, cited and I have placed that, and his lordship was almost pleased that yes, there is a one judgment of the latest Supreme Court. My lord, I think that is on the record also, that in a similar circumstances, when issue is same, issue is one, then one appeal, my lord, suffice for
But
the
then in
all
the-
the appeal.
But Mr. Sen, in this appeal, we will only hear Mr. Jana. Nobody is representing the other.
No, they are representing all.
Oh, you are representing all?
Yes, তাহলে কাকে?
some of the writ petition, not for all.
Then the problem is, whom do we hear?
আমার নেই বেশি, আমার 4-5টা
Well, let them.
No, কঠিন mathematics.
No, no.
No, no. আমার নেই বেশি, আমার 4-5টা আছে, আর
এবার
বাকি
তোমার
সব
সবাই
order
hold করছে না। না, আমরা যে অর্ডারটা পাস করবো
cover only the persons that সবাইকে নোটিস দিয়েছে
কি আছে বলে তো।
this where is your memo of appeal দেখি
এই যে এখানে লেখা আছে দেখুন, এটা হচ্ছে অর্পিতা সাহা, এটা কেপি সামন্ত।
Oh,
এগুলো সব lawyer।
you have preferred the appeal so far as Swapon Chakraborty is concerned. None other. Your memorandum of appeal is you are challenging an order passed in the WP filed by Swapon Chakraborty.
স্বপন চক্র।
অন্যগুলো করনি।
দরকার নেই, অন্য করার দরকার নেই, একটা জাজমেন্ট তো, কমন জাজমেন্ট একটা।
no it's not an order in rem দরকার আছে it is not it can't be construed as an order in
May I tell lordship? Well, this question also came up in my mind also. I asked him that when you file this, why not? Because premier tier judgment was the first judgment of the Supreme Court that one has to file separate at least memo in respect of all. But the latest judgment, Malad, I have seen, Malad, I think, Malad, it is Malad of 2022 or 2023 judgment, and I have, Malad, placed the bench also that আমার কোথায়?
আমরা যদি Inspector Swapon Chakraborty, আমরা যে judgment cover করি, that is a question to be decided by the other
I'm covered by your without covered without hearing the writ petition
No,
which দরকার নেই
ও তো নথি তো সেই পড়েই আছে।
Yes, lordship, 2020, volume 2 SCC, page 173. I have cited that on the
No, is it your stand, Mr. Sen, that you are,
one appeal suffice to cover all
but
when
that
issue is
that is not your memorandum also. Memorandum says only one
one
person.
appeal. But if I succeed in one, then that will cover all. That is the Supreme Court judgment of 2020. That there is no
Even
need.
though memo has not been filed.
Even no, there was still manner the same question cropped up.
একটু স্টেপল করে দাও, ভুলে গেছে।
Then if it is to be hard together, then we have to hear the other writ petitioners also. You have to issue notices to them.
Well, as per this judgment,
No,
2020 volume 2
No,
SCC,
I don't know what is the
Supreme-
এটা কি একটু স্টেপল করে দিও। I don't know. You check it up. You check it up. Otherwise, our judgment will be, if we uphold the order.
restricted to. But my lord, that is why, my lord, I placed
What
this
is
judgment.
your stand? Do you want to restrict only in respect of support?
No.
So then you have to
Then
issue
our
out.
then that is our purpose would not be, my lord, subserve because of
Then
the fact
how
that
the
in case of others,
I think
then
this was
only-
not brought
if
to
I
the-
succeed, then, my lord,
If you succeed or whatever the
whatever be the result,
result,
yes,
your contention will be all others will be
my
covered
lord,
by.
my lord.
But then
The
without
judgment
hearing
in
them,
name হবে না তো।
না রেম তো হবে না।
It
Well,
will be
may
a
I-
judgment in personam, only in respect of support.
It may cover the others for subsequent appeals or, but then
Your appeal against the other persons are already time barred.
My lord, may I tell, my lord, the exactly, my
So
lord,
please go
that
through it and satisfy
my
us.
very good lordship, my lord. Well, out of 40 or 50, my lord, matters which were disposed of and matters went up to the Supreme Court in this matter,
We are not
then
on
only
that,
seven,
Mr. Sen.
well, may I tell, only, my lord, SLP file only in respect of 7 appeal paper, not against others. This question came up and then Premier Tier and other Supreme Court judgment referred by the respondent therein, and they say that this appeal is either not maintainable or restricted to those only who preferred this SLP. The Supreme Court, after going through the entire thing, matters, and says the issue is one. And if this issue is answered in 7 or 1 or 2, then that should be, my lord, covered in all. Because issue is one, we have to answer the only issue. So, irrespective of the fact the others have not, but that is covered. And say that there is no necessity. But yes, I have followed what fell from your lordship that
তরুণের against the appeal is time barred. So he has
case will be guided by whatever order আমরা এখানে পাস।
that
ওদের তো অ্যাপিলই নেই যে ওরা এসে অ্যাপিয়ার করবে।
আমরা শুধু pass a separate issue only in respect of Shopon. If you agree, we will hear. Make up your mind.
or, my lord, may I tell, it appears from the, my
This
lord,
is an order against Shopon Chakraborty,
my lord,
restricted to Shopon Chakraborty.
Yeah, sure.
Memorandum of appeal says so.
মানে
ওদের তো এগেনস্টে অ্যাপিল করা হয়নি। অনলি টু লার্নের অ্যাডভোকেট
একসাথে করেছি।
কৃষ্ণপদ সামনে
মানে এরা অ্যাপিয়ার করেছিল।
আদার্স
Hostile তো তোকে
Meaning
ওদেরও
আমি
থাকতে হবে।
ওদের ওই যে লেখা আছে 22 থেকে 58
একসাথে প্রিন্সিপালটা সবার ক্ষেত্রে
এটা কারা? এই যে ওর কবিতা ভুঁইয়া,
এরা ওদের ওই মামলাগুলো আর বাকিগুলো আনছে। এই যে এখানে লেখা আছে দেখুন।
আমার আর
ও আই সি, তা সেটা বলো।
কিন্তু উনি appeal তো আপনি একটা
কভার করে যাচ্ছে কন্টেন্ট
হবে না।
ফিল স্বপন চক্রবর্তী মিনস আমি
মানে মে আই টেল লর্ডশিপ,
No, you study
may I just
assist. We are not.
my lord, I want to assist your lordship, my lord. Yes, it is my duty.
We will.
No, my lord,
Mr. Sen, apply your mind. If you are ready and willing, so far as Shopon is concerned, we will hear it. We do not want to decide any other point here.
No,
We
but-
have not been called upon to do so. Suppose we set aside the order Only in respect of Swapon it will be set aside. Now in the remaining matter, if contempt is filed, you will argue that point, that that issue covers all these requests. That is for you to argue.
No, that would not be, my lord. I think I may not succeed in that way.
Only you
only
take
thing,
instruction.
no, my lord. Yes, my lord. Only thing, my lord, one or 2 minutes, lordship. But it appears from the impugned judgment that bearing 3 or 4 matters, in all matters, my learned friend appeared on behalf of the read petitioner.
Very good. If
So
he appears,
if he, my lord, agreed to appear,
no, he will never agree.
Only appeal has been
Just
referred,
say
only
he
against
will
support
no,
agree.
it's a case of sufficient representation.
He wants
So kindly
consider,
consider.
sir. He
My
will
lord,
not agree.
no, or my lord, it's a case of
We are not
sufficient
entering
representation.
into that. We are not entering into that.
All right, may I just discuss this issue, my lord?
Please discuss an issue করো Thursday আজ কবে Thursday week রেখে দাও
My
yes পাসওয়ার্ড ডাকো Thursday week
my
15 দিন বাদে
Thursday week.
you check up
Yes,
you
ma'am.
say we are restricting, we will not record your submission.
No, I have.
We will not say at all whether it is restricted to Swapon or not. We will only decide the appeal of Swapon preferred by the state. Finished. আসুন দেখো পাসওয়ার্ড দেখো হ্যাঁ এর মধ্যে লোকালতনামা যোগ করতে পারিস না
My lord, in this matter, this pertains to this compassionate appointment, as lordship has already passed one judgment on this particular issue and passed an order. My lord, thereafter, the coordinate bench, my lord,
we passed an order of in the first matter Mithun Acharya, we passed an order in Pritam Mollik.
my lord,
Pritam Mollik, there is no stay of the impugned order,
My lord.
stay of the contempt.
my lord, my lord, my lord. My lord, but thereafter, my lord, the coordinate bench, on the basis of this Binapani Murmu judgment, as the matter is pending before, the main issue is whether this compassionate appointment without the scheme, my lord, this issue is now the Honorable Supreme Court is in session of the matter.
Session
lord-
of the matter, only contempt proceeding state.
My lord, may I just indicate, my lord, 2 things, my lord, on that this basis, my lord, thereafter, 2-3 orders, my lord, today I am basically, I am without the brief also, my lord, anyway, my lord, I am having, my lord,
This
if your
is
lordship,
another matter.
yes, in another matter, thereafter taken up, my lord, on the basis of the same, considering this Binapani Murmu, the stay of operation of the impugned order is there, my lord. At the 3rd page of the order, my lord, if your lordship kindly sees, my lord. And thereafter, there are other matters also, my lord. Today, I am lacking with the brief, my lord. If your lordship keeps it tomorrow also, my lord, I will bring all the necessary judgment, my lord.
No, we wanted to know from your junior whether the similar order has been stayed or contempt proceeding in connection with the writ petition has been stayed.
No, my lord, in this matter, my lord, the same,
The Sudipto was not placed before us.
my lord, I know.
Which has
There
been
are other
prepared-
judgments also of the coordinate bench, my lord. Now, the stay of the operation of the impugned judgment itself is stayed now, my lord. The 3rd page of the order, my lord, if your lordship kindly have a look, my lord. But tomorrow I will bring the copies for your lordship, my lord. I am
decision be up to Binapani. Come to the page 85.
my lord, it is from তোমরা পারবে না এটা অন্য ম্যাটার আছে
Binapani কিন্তু
ওই যে জাজমেন্টটা
শোন আর কি, decision in
হ্যাঁ।
Binapani. এইটাই ফাইন করি করে এবার স্টে করি বিনাপানিতে তোমার হচ্ছে গিয়ে
এটা দাও এটা বিনা পানি মুটা দাও একটু
বিনাপানিতে
বিনাপানি মুটা
আর ও বললো বিনাপানি ডিসিশন সেজন্য স্টে করে পড়েই দিতে পারি আর
contempt pending. Now, brother, the entire issues, malad, in other matters also, Shayanaditya and all, malad, these are pending before Honorable Supreme Court. Malad, Supreme Court is now, malad, therefore, the main judgment.
I think we are not being able to make one. We understood Supreme Court is in session. Supreme Court has
State the contempt proceedings.
Contempt.
My lord.
We want to know whether because your junior was saying that stay the order because there is a similar order. But unfortunately, no similar order was. This is first time when you are appearing. This is being shown to us.
Well, this is also from some other briefs, my lord. Actually, I'll come up with tomorrow, my lord, with appropriate. May not be palatable to your lordship, my lord. I'll come up tomorrow, my lord, with the appropriate orders. There should be 2 copies, my lord. I am
To be mentioned Tuesday.
tendering unconditional apology, my lord, for the same, my lord.
Come with those orders, Mr. Ganguly.
My lord, it is required. It is
Order
required.
is state.
My lord.
We were unable to.
I got your lordship, but certainly today, my lord.
Oh, this appeared once previously. You were not there.
I have not appeared, my lord.
No. This matter.
Yes,
appeared
I
previously.
understood, but
Day before yesterday, my lord.
Yes. You are not
my
briefed.
lord, anyway,
You are not there.
my lord, I'm not there
So
actually.
he said that you are.
He said at the one point of time this was settled by me. That's why he's saying that ultimately I am neither having the brief or nothing. I'll take whatever it's. I'll take the
Then who is
responsibility.
your
I'll come up.
senior? Who is your senior in this matter?
Yes.
টা তো দেবে, briefটাও না থাকলে। My lord, I take the responsibility, my lord. I tender unconditional apology, my lord, for the inconvenience caused, my lord. I'll come up, my lord.
Yes, next meeting. Tuesday to be mentioned, Mr. Pal. আরেকটা কি আরেকগুলো কি এসছে ও where is yes where is Mr. Lairi সে আবার কোথায় গেল হ্যাঁ
He's on late.
My lord, I'm the appellant, my lord.
he's saying similar order passed.
Yes, my lord. A single subject teacher.
Lordship has decided the issue, my lord. Similar order may be passed. Regarding the correction, willing teacher.
Affidavit of service.
হ্যাঁ হ্যাঁ
My lord, order টা দেন। My lord, for the petition. These are the similar order, my lord. কোনোটা দিচ্ছ কেন?
order was same order by the single judge.
Same.
By the same single judge, but
Same order. This is your lordship.
So you sit with Mr. Das, correct it. We will pass that order. Mr. Roy.
Yes.
But I am for the school authority, your lord.
Very well.
School. তুমি কি বলবে আর?
My lord,
We will record your presence. You know that order?
I have seen the order.
Handed over. This
You have any?
Actually, the problem is, my lord, the school has in normal section
We have not
1,061 students and only
we have not considered as regards the school because we have said that it has to be done as per that circular irrespective that it is not that first willing has to be found out then placed. DI will take a decision expeditiously in terms of that. That is the order.
But my lord, at the same time, my lord, kindly ensure that once teacher be
A replacement teacher will naturally have to be found. The substitute
otherwise
teacher.
the student will
yes.
suffer.
That is the order.
That is the order.
The order we
We
have.
have already given no objection. We only need a teacher, your lordship.
Correction করেছো?
আমি করে দিচ্ছি। I'm just giving handing over.
তো make the correction কত কোনগুলো 1 2 and
2,
3.
3, 4. 2, 3, 4.
2 and 3, I am appearing on behalf of the petitioner. In
I
4, my
commit.
lord,
Mr. Laidi, you sit with Mr. Roy and you make the corrections. DI respondent number, it is very difficult. We pass 3 orders, na? So whatever corrections you want to in, you made in, that will be here.
Yes,
And
Mention the item and the.
I will do it. I'll do it.
3 matters.
3 matters.
Item number
2, 3, 4.
2 3 4 disposed of.
but in item number 4, Mr. Mitra is appearing on behalf of the commission.
Similar matter.
Okay, Mitra.
No, but you better inform Mr.
Where is Mr. Mitro?
My lord, he has come, my lord. He told me that he is engaged before another court, my lord.
Acha, then
With Mr. Mitra and
acha,
Sitting with Mr. Mitra.
he is appearing in all the matters.
No, my lord.
4.
Only in 4.
So, Mr. Lahiri, in the 4th matter, you include by hand Mr. Mitro's
I will make all the corrections placed before your lordship. So lordship kindly.
disposed of.
But the item number 4 is of 2022, where your lordship sitting with the brother judge, my lord, your lordship passed order in Papia Vishwas. That has still not been complied with. I won't say complied with. She has not got the relief till date. 2022 4th rounds of litigation. Your lordship passed order referring to 3rd January
Apia has again come us.
before your lordship. First, your lordship passed order, that single bench order, single subject teacher we challenged before your lordship presided over my lord Justice Chakraborty.
No, Papia in this 2, 3, 4.
Yes.
Oh, Papia now made a fresh application.
After your lordship's direction, your lordship directed to follow 3rd January notification, single subject teacher will not be a bar. DI passed the same order saying that willing teacher. That was challenged before the single bench, same order. Now it is before your lordship again. It's a circle.
Same order means that
willing teacher.
That willing.
Since 2022.
But you have not preferred contempt, Mr. Light.
No, I could not prefer contempt.
In the present matter, your lordship has fixed the time, my lord.
Yeah,
You have given.
So the similar, I will do the needful, my lord.
ঠিক আছে, 2, 3, 4 disposed of.
I will be handing over to your lordship's officers this copy.
Please give the item number.
I will do everything.
Include his name as full.
In respect of 2, right? Number 2.
আচ্ছা কে appear 2 তে কে appear
I am being led by Mr.
এই লেখো তো 2 নম্বরে ওদের appearance লেখ
তুই তো একই আছিস
for appellant
ও দুই তে আছিস আচ্ছা
দিয়েছে 2 নম্বরটা দিয়েছে
Yes, my lord.
in item number 2 you are for the
My lord, I am for the state, my lord.
you are for the state in item number 2 দিয়েছে হ্যাঁ কি নাম দিয়েছে কৌস্তব ভট্টাচার্য very good for the state আচ্ছা
Respondent number 7 and 8, my lord, school, Kollan Kumar Pond.
and in the you are the school in item number
2,
2 3 and 4 school has not come
different.
Item 3, my lord, I am for the state.
This is evident from sir.
Item 4, I am led by Mr.
তুমি একটু ওই কত করে ওই অর্ডার তিনটে দেবে তুমি অ্যাপিয়ারেন্সটা বসিয়ে ওই অর্ডারটাই ছেপে দেবে যেটা কারেক্টেড হয়ে আসছে ডোন্ট কমিট এনি মিস্টেক
No. I will do it. I'll do it. Please.
Again it has to come up for correction.
No, I will try not to, my lord. I will try not to. Affidavit, sir.
কে হ্যাঁ সৌরভের নামটা নীরোৎপল চ্যাটার্জি আর কার জন্য
My lord, Lokpal Charaj, my lord, he is appearing. I mean, just now he was in online, my lord. Replace, my lord.
ইয়েস ওদের নামগুলো দিয়ে দিও সব
Disposed of. Extremely good.
এভিডেভিট অফ সার্ভিস ইউ হ্যাভ ফাইলড
I
ইন
filed. I filed.
ওই এভিডেভিট অফ সার্ভিস দিয়ে দাও বাঁচা গেল
বসে যাও আমি পুরো তোমাকে দিয়ে দিচ্ছি তুমি একটু দেখে নাও
খুব খোঁজে যাবে এই কোথায় গেল ইন আইটেম 4 there is a section 5
section 5 আছে Papia Bishas has section 5
আচ্ছা সেটা তো বলতে হবে
I'm very sorry I just missed it my lord kindly forgives me for that my lord
কোথায় গেল পাপিয়া বিশা you are there
My lord, Mr. Mitra is there, my lord.
commission
Commission.
and you are
My lord, I am not. Mr. Mitra told me to appear on behalf of the
he's for the state you're for the state right
He is for the state, man.
so just now who appeared for state in item number 4
In item number 3, Mr. Bari is appearing.
I am appearing for the state. Item 3, I appeared for the state.
Item 3.
and item 4 who appeared for the state
My lord, I appeared for this.
what is your name
My name is Tirupati Mukherjee.
কি বলে
Tirupati. My lord, Mr. Shopon Banerjee, I am led by Mr. Shopon Banerjee. But he was there.
who is the Shomon Chatterjee
But he is the panel lawyer of the state.
so he is at home or he is in court
Mr. Banerjee was appearing he came Mr. Banerjee was there
দিয়ে দাও এই আইটেম নাম্বার 4 এ ডিলে অফ হাউ মেনি হ্যাঁ
172 days
ওই একটা 172 দিন
after Justice Sen's order my lord we have come since this willing teacher portion was omitted that is why it took some time my lord otherwise she is suffering from
who is your other side state and commission are you opposing
no
তাহলে ওই একটা উপরে ওই ক্যান নাম্বারটা দিয়ে as we have invited the parties to our
May I just draw your lordship's attention in one matter. There are two directions. One direction is upon the school to forward, then DI will find the willing teacher. So that portion, forwarding by the school to the DI will remain.
Daidi, make up your mind and say again you are adding another step.
No, I just informing your lordship since I have to make the correction.
It cannot be the same order.
No, same portion. The willing part portion will be there. Only one additional thing, one difference is there. The learned single judge has directed, since it was pending at the end of the school authority, school was directed to forward it to the DI, then DI will find the willing teacher. So first portion will remain. The next portion is to be touched. May I
Is
just,
that matter?
Item 3. Item 3.
It is pending at the end of the school.
School authority.
Dekhi item 3 da and show the order which you have passed.
Yes.
See,
Papiera দাও, papiera দাও।
বুঝেছো তো?
পিএলি আরেকটা দাও।
ওই অর্ডারটা নাও, ও যেটা দিচ্ছে দেখি
করে দিচ্ছি।
একটা নিয়ে বসবো যখন তখন 1000 টাকা
দাও আমাকে। 3 নম্বরটা মিনার হবে।
বলছো?
এই তো forward page.
Okay, same thing.
Page 140. Last paragraph.
In item 2, 3 and 4, the order passed by Justice Bhattacharjee is same and identical.
Same and identical.
Then how it is not identical?
Only one portion is.
Then how we will add this?
This willing teacher portion is there in this order itself.
You said pass the same order, everybody agreed. Now when we will sign the order, we have quoted a portion of that order.
I will make corrections accordingly. That is why to
What corrections you will make?
That willing teacher portion corrections I will be making accordingly. Only.
Sorry, sir, we don't allow such correction. You will be striking down any portion of the order.
No, there is only one additional thing that is in my favor.
Take the order. Take the order which you have handed over. Come to the second page.
Yes, ma'am.
First page we said disposed of the order impugned observing inter alia as follows. We have quoted a portion of this order.
Yes.
Is the same paragraph there in all the three matters?
Not verbatim, but it is there. Not verbatim, but it is there.
So why did you say then? Then we would have
That's
taken
why-
a one by one.
That's why I've drawn your lordship's attention because it is there.
Mr. Lady, it is.
No, I have to show to your
We are believing you. We are passing the order, and when I will go to chamber, when I will see, we have to again keep it as to be mentioned.
That is why I drawn your lordship's attention. That's why I drawn your lordship's attention, my lord.
That's why you didn't draw. After we passed the order, we said same matter. You came running and said that you had this.
No, it's I felt that I should inform your lordship, my lord. Kindly take page 140 for once. That would be clear, my lord. Page 140, last page, last paragraph.
এটা কত নম্বর আইটেম?
3.
2 নম্বর আইটেম দাও দেখি। একটা একটা করে চেক করতে হবে। এটা রাখ। 2 নম্বর আইটেমটা দাও। তুমি লাই করে চলবে বলো।
Page 129 of the application. Second paragraph is the same, having considered.
Yes, what is your contention?
Same. 2 is
What
same.
same?
2 is same, having considered.
It is not the same. The ordered quoted portion is not the same.
Lordship is referring to item number 2. Rupak Dua. Yes.
Quoted portion is not the same.
Yes. That is pending at the end of the school. That's why I submitted your lordship. That portion will remain. That it is pending at the end of the school. That kindly see page 130. Having considered the submissions made on behalf of the parties, writ petition stands disposed of directing the authority of Pundak High School, Purulia, being respondent 7 and 8, to forward the transfer application of the petitioner to the District Inspector of Schools, SC Purulia, being respondent number 5, by 7 days from the date of communication of these orders. This will remain since it was returned back towards the end of the school. So this portion will remain. The next portion, on receipt of transfer application, respondent number 5 shall make an endeavor to find out willing teacher of neighboring school who can man the post of the petitioner temporarily till regular incumbent joins the post on transfer of the petitioner. This is covered by your lordship's observation.
Make an endeavor.
Not just in item 4, Mr. Lahiri, all the matters, this at least in 2, also this issue is there that the school will have to transfer the petition to the DI, forward the application to the DI.
3 and 4. Kindly, my lord, kindly give me a moment. Yes.
This issue is there in all the matters.
Yes. That I should have.
And you said only item 4,
No,
but it's
I should
there
have.
all 3.
I should. It's my mistake, my lord. It's absolutely my mistake.
This paragraph is completely different.
I have committed a wrong, my lord. I tender my apology, my lord. It is my mistake. I should have said that. It is my mistake. Absolutely my mistake. I mean, I'm extremely sorry for this. I'm extremely sorry for this. I should have, my lord. নেক্সটটা দেখি 4 নম্বরটাও দেখি এগুলো একটু বলো না এগুলো একটু বলতে পারো তো আমাকে ইয়ে হয় আমার এগুলো
রিকল করে দাও অর্ডারটা পুরো চেঞ্জ করতে হবে হ্যাঁ কিন্তু এই লাইনটা তো নেই প্যারাগ্রাফ পেজ 4 এ পেজ 5 এ আসো রেডি আমাদের এইখানে একটা রাইডার অ্যাড করলো বললাম in the said notification there is no rider that has to make find out any willing teacher who can man the post of the term willing does not feature ঠিকই আছে সেট আউট পোর্শনটা চেঞ্জ হয়ে যাবে Content does not take urgent time to get from the single teacher person has applied for. Modify keeping the error. You are in item number 2 for the school.
For the school.
No, have you already forwarded?
My lord.
So they have already forwarded.
Yes.
Then what you are saying to be added?
That the DI, that willing teacher portion is to be not to be there in the order. That portion may be removed, my lord, or modified accordingly.
And DI also taken initiative to find out a teacher. Yeah, আমরা যেটা
willing
noviation
না এটা না DI কোথায় স্টেপ
substitute teacher.
DI has
We have already given no
again
objection.
same thing. Again same thing.
Which one?
School has
Item number
forwarded.
2 forwarded.
The school has forwarded to DI. DI again has written willing teacher.
When is the memo?
He's showing.
When is the order?
My lord, we have forwarded on, my lord, 21st April 2025
After the single benches.
in compliance of the order of the honorable single judge.
Very good. Now, that order was passed by DI prior to our division bench order. What is
Yes, my lord.
What is the date of that order?
30th April 2025. DI's order.
PLE Chakraborty.
That has to be set aside, no? In one matter, we have set aside the order of the DI.
Yes, yes.
Which is that matter?
বনশ্রীটা দেখি বনশ্রী আরেকটা ছিল পিয়ালি চক্রবর্তী বনশ্রী সঙ্গীতাটা দেখি
There we have passed another similar order where we have set aside the order of the DI. Now, after that rejection, have you again sent?
No, ma'am. DI has not rejected, your lordship.
My lord, in terms of the
Rejected?
No,
not rejected, my lord. They have.
he has
DI
taken
made
initiative
endeavor to find out.
So that order has to be set aside.
দেখান না জজ সাহেবকে দিতে
Where is that order passed? Where is that order we passed?
সঙ্গীতা জানা
আইনি বলে দিয়েছে
পান একটু দাঁড়াও।
এটা দেখো তো আছে কিনা এটা দেখো তো
এই যে
এটা দেওয়া তো
তিনটেই হয়েছিল না পিয়ালি চক্রবর্তী তো নেই তো
আসো দেখি item number. Have you got that order?
But I'm just giving. There are 3 orders.
In one order, we have set aside the order of the DI.
Lord, in this matter, my lord, in item number 2, my lord, district inspector of school has not rejected the claim of the petitioner. Rather, my lord, he has, my lord.
We understand. That was similar. We said that was he sent letters. Those have not been sent back.
বনশ্রীটা পিয়ালিটা দেখো তো পিয়ালিটা দেখো তো This is the order. বনশ্রী আর একটা কপি দাও একটা মিনিট একটু দাঁড়াও সেকেন্ড পেজ ফার্স্ট প্যারা
এই অর্ডারটা আমরা সেট aside করেছি।
That DI has also said that. একটা সেকেন্ড দাঁড়াও
আচ্ছা তাহলে এখানে করো আইটেম নাম্বার 2 নিচ্ছ তো নাও ট্রান্সফার এখানে কি হোয়াট রূপক দুয়া এখানে হি হবে হি ওয়াজ দি সিঙ্গেল অ্যাসিস্ট্যান্ট টিচার
of mathematics
assistant teacher of mathematics under science group in name of the school
Pundar High School within bracket HS
Pundag, Pundag, Pundag High School, HS. First an order stating that no willing teacher is. ওইটা দিয়েছেন, ডিআর কপিটা দিয়েছেন? দিয়েছি।
এইখানটা না পেজ, এই যে লিখে দিচ্ছি, পেজ 130 অফ দিস ডে, এই যে এখানে দেখো মার্ক করে দিয়েছি, এখান থেকে এতটা ঢুকে যাবে। ডিআই অফ
পুরুলিয়া,
পুরুলিয়া।
ডিআইএসি পুরুলিয়া।
যে দেখছি 5, let's for number 5.
ইনকর্পোরেটিং রাইটার এটাও করতে হবে এখানে। এই যে এখানটা করেছো না পেজ 3-তে, এই পোর্শনটা কেটে এই বিলিং থেকে লাস্ট অব্দি বসিবে কোট আনকোটে, ওখানে রাইডারটা ডিফারেন্স। এই পোর্শনটা ঢুকিয়ে দিই ইন্টারনেট বেসিস, সেটা তো হ্যাঁ। এখানে বললাম ইনকর্পোরেটিং আ রাইডার টু দি এফেক্ট দ্যাট ইফ উইলিং টিচার ইজ ফাউন্ড, এটাও সাবমিশনে ঢুকছে, লাহিরি সাবমিশন। Effect that এখানে আছে, make an endeavor to find out willing teacher from willing teacher.
একটাই আছে কিন্তু একটু কম ধোয়াটা হয়ে গেল।
রাইডার টু দি এফেক্ট, এই জায়গাতে এটা কি একটা স্কোয়ার দিয়ে দেবো, রাইডার টু দি এফেক্ট দ্যাট
কোনটা স্কুলকে বলা ছিল ইয়েটা দেখি।
then I can endeavor find out meeting of neighboring school. Who can man the post of the temporary irregular income joins resulting vacancy. Joins
After correction are present, either to expect that
এই যে এই জায়গাটা না আমি এরকম স্কোয়ারটা দিয়ে রাখছি, এই স্কোয়ারের পোর্শনটা ওমিট হয়ে এই স্কোয়ারটা এই হ্যাশটার বদলে শ্যাল বলে এই স্কোয়ারটা শ্যাল মেক অ্যান এন্ডেভার এবার এই যে মিস্টার মিত্রর পরে মিস্টার নামটা কি বললো না স্কুলে এটা চেঞ্জ হবে কিন্তু স্টেটের যে নামটা চেঞ্জ করে দেবে স্কুলের আইটেম নাম্বার 2 তে মিস্টার পান্ডা
কল্যাণ কুমার পান্ডা
এইখানে এই যে এইখানে ঢুকবে এই যে আমি এখানে করে দিচ্ছি মিস্টার পান্ডা লার্নেড অ্যাডভোকেট অ্যাপিয়ারিং ফর দি স্কুল
It had already reached to the end of the commission earlier occasion. On that ground, it was rejected single subject teacher.
The last
That reached,
application-
please. That reached to the commission only after school issued NOC through DI. The previous application reached to the end of the commission. Commission rejected on the ground of single subject teacher. Then when it was came back to
This
me,
is of 2021.
yes, the last application is also of 2021.
Which application?
That my learned friend has shown 25th September, serial number 2.
Latest application.
Latest application is also of 2021. Now, what is happening when your lordships are passing these orders, the school authority is calling us or the DI is calling us that you kindly give your documents. Documents are submitted and they are forwarding it. So it is being done in that way. Am I clear to your lordship? Kindly take serial number 5.
What is 7/10/21 serial 1?
Serial 1 is, my lord, the return by the school authority.
That is not eligible.
On just because it has already been rejected on the ground of single subject teacher by the commission, serial number 5. On that ground, since once the commission has rejected on the ground of single subject teacher, schools are no more allowing my application because the highest authority has rejected on single subject teacher.
Then you have to make a fresh application.
If your lordship so directs, I can always make a fresh offline application. But usually, when these orders are passed,
If your lordships kindly, turns to page 132. Petitioner make, my lord, several application. Firstly, on, my lord, 9th of August 2021. Serial number 12.
Have you served upon the school?
Yes.
Where?
affidavit service, it is there, my lord, the affidavit of service. May I just check? দিয়েছো তো, ডেলিভার্ড হয়েছে তো, দেখেছিলে তো?
And in the other one, next matter?
4.
4 also same.
No. 4,
my lord.
no.
My lord,
4 is,
MITRA is
I am telling your lordship, 4 DI passed an order that willing, pursuant to lordship's direction, DI passed an order for willing teacher that was challenged before the honorable single bench. Considering that, the honorable single bench said you keep on searching for willing teacher. That was challenged before your lordship. Next matter, Papia.
See, Mr. Laidi, how you have misled the court.
No, my lord, I did not have any intention. I came back, that's why, my lord. I realized it is not
bother
correct.
us.
No, I
Be
realized it
careful
is
in
not
your
correct.
profession.
No, I realized, my lord,
When
it
the
is not
court
correct.
is believing you,
Yes. My lord, kindly forgive me for my
how
mistake.
many times forgive me?
No,
You can
I
be
did not have any intention to mislead your lordships. I came back, that's
whether
why.
intention
I
you
realized.
have, if it is a grave mistake on your part,
I
if
understand,
you are
my
not sure about the case, who prevented you from saying that, my lord, I will come tomorrow with the enter?
I missed that.
By hook or crook,
No,
break the order.
no, my lord. I came back, that's why, to your lordship. My lord.
This would be the impression of you to the mind of the bench, unless we had known you previously, that you had appeared in similar matter before us.
Yes, my lord. I am sorry. I am very sorry for that, but I have no intention to do that.
40 word does not cure your defects. When the court is reposing faith upon you,
I
you are
understand it.
not telling the facts to the court.
I realized subsequently that there is some mistake on
When
my
did
part.
you realize you are not a toddler now in the profession?
I came back to your lordship. That is why I realized that it is not correct.
Pardonable. As if court is taken for granted. One order, forget about a lock, stock, barrel, all matters, you say similar order you pass.
No.
Sorry, sir, we are not that sort of a...
No, not at all. Not at all. It is not at all. The issue was that it is not at all.
ওই শুধু 2 এর অর্ডারটা করবে, পরেরটা adjourn for 1 week.
I'm grateful to lordship.
Please inform Mr. এই 2 এটা 2 হলো তো, আর 3 নম্বরে অর্ডার লেখো, ওই কস্ট টাইটেল দিয়ে দেবে, in course of hearing Mr. Lahiri learned
Just be kept with the record. I've already handed over the affidavit of service. That be kept with the record.
তাহলে দুটোতেই দিয়েছে?
Yes, yes, yes.
এভিডেভিট অফ সার্ভিস as ফাইল
নাম দিয়েছে তো চারে
kept on record.
নাম চারে আছে
থেকে উঠতে বল 5 মিনিটের জন্য।
12ই আগস্ট 12ই আগস্ট
Your matter we have disposed of, Mr. No, Mr. We have recorded and we have disposed. You're coming back after 2.
Well, in item number 6 is also relating to this compassionate appointment, my lord. Can this also appear on Tuesday, my lord, if
Yes,
put
yes.
the matters?
Same.
Same. It will come at the same. Well,
You
there
have
is only a
signed-
delay of 74 days, my lord.
Oh, have you served the application?
Service affidavit of service ko tha.
Today the service is not with me, but I have
So
served.
we'll bring the affidavit of service. It has been served.
When did we keep it?
No,
Tuesday.
Tuesday, both of them.
Tuesday রেখে দাও। হ্যাঁ, ওতেই রেখে দাও। ও বলে দিতে হবে না। অর্ডার করে বলে দিতে হবে। তুমি মেনশনডে ওখানে না, ওরা তো জানবে না না, যদি কেউ অ্যাপিয়ার করে তো জানবে।
The affidavit of service is not with me, but I have served. The next day I'll file my affidavit of service. I have served through post. All of them have.
Mr. Ganguly, learned senior government advocate or AGP.
AGP.
Is there? কোথায়?
দেখো
লিংক নিয়েছিল না?
মেসেজের এতে রয়েছে উজ্জ্বল রায়।
কি বলছিল?
I am in item number 11 for respondent.
I can't change it now. মানেটা কি? এই বাবা, এটা মানেটা কি?
এখন আর নেই।
Mr. Ganguly, Mr. Ujjwal Rai is the Writ Petitioners Council.
Well, I'll
Do you know him?
Well, I'll serve well, I'll take his number.
Ujjwal Rai and Orpo Chakraborty, we saw it in he was there online. Kindly mention the item.
But it has been mentioned that item number 11.
Oh,
But
he
এটা তো উজ্জ্বল রায় আছে।
in this matter
Item
also.
number
No,
in this
here
matter
it
also.
Matter also, Ujjwal Rai appeared for the Writ Petitioner.
Well, I'll serve. I'll get the number from there only.
Yes, next.
I'm grateful, Melon.
Yes. 7. You are for the appellant. Who is there opposing him?
In the read petition, Mr. Supriyo Chattopadhyay was happy.
Then
Was
come
there.
tomorrow
Not tomorrow. I have personal difficulty.
to tell us next Thursday. Next Thursday. Yes. দেখে যাও লিস্টটা ডাকো। Advocates have not come or what? Advocates have not come.
The entire code number 19, entire combined list has been called off. So many codes,
Code number
19 and other code. Some others code, since there is, the resolution of 3 associations, that is.
Yes, item number 9, you are there. We take it up tomorrow.
Item number 2.
Appellant.
School authority,
Is this transfer matter?
This is also transfer matter.
You are for the school.
School authorities.
Samiul Wadi. He
Yes.
was just now here. Achata, not today. Yes. खाली तो সিক্সটা তো 2 PM নাকি? না, ও না।
And for the respondent.
Respondent,
Great.
assign matter. What are the applications?
Can 4 and can 1.
What application you have filed? Oh, জানে না। Not today. Assign matter. What is the matter about? Do you know?
Mat suit of 2000.
Mat suit. It has been assigned to us. Huh? How that can be a mat suit? You have come to the wrong court. No one.
Connecting matter.
Uh-huh.
It's a connecting matter. Can 4 was filed.
Aha, you are saying it is a mat suit. It is not a mat suit.
1509.
The mat number. The mat suit. Mat suit becomes a matrimonial suit. Indian Bank. You are for the Indian Bank.
And the respondent number 8.
এটা কোত্থেকে পেলে গো অ্যাসাইন? ছিল নাকি আমাদের? হ্যাঁ? আমাদের কোনো কম্বাইন লিস্ট আছে নাকি আর?
না, combined list.
চলো 2টোর সময় আসবো। 2টোর সময় ওই স্যার
86 থেকে।
ডাকো। দেখে দাও তো। 2টোর সময় আসছি।
But may I continue, my
Mr. Mojumdar, we would request you not to repeat the grounds.
lord? I tell you, lordship, my lord.
No,
Till
it
now, my
happens
lord.
na, while
Till
arguing,
now,
it
my lord, I have made every attempt not to repeat anything, and I will do so, my lord. I will do so. I know, my lord, time of the court is very precious, my lord. We kindly, my lord, take compilation 1 straight away. Well, I have addressed the issue of publication of panel. I have also addressed the issue that they cannot rake up the question of reservation in this matter, since there are 21 common petitioners, admittedly, and in paragraph 28 of the writ petition clearly say that this is.
Mr. Mojumdar, you just summarize what you have said.
Well, I have just summarizing right
Just
now.
summarize point wise.
First point is that panels were duly published and made available in the offices of district primary councils.
Yes.
They were affixed on the billboard. There is no provision in the rules regarding the manner of publication of panel. Hence, my lord, on a conjoint reading of section 60, subsection 1, clause K, read and rule 5 of the 2016 recruitment rules, the panels were made available by the councils because it was district-wise panel. It was never a state-wide panel. B, my lord, reservation. So far as the issue of reservation is concerned, your lordship will find there are 21 common writ petitioners. So far as this writ petition is concerned, the one filed by Priyanka Naskar, which is being heard by your lordship. And these 21 writ petitioners were parties to two writ petitions, two sets of writ petition, one before which was decided by Honorable Justice Arijit Banerjee, and the other set was decided by Honorable Justice Hiranmay Bhattacharya.
1 plus 20.
1 plus 20. And there is a specific averment at paragraph 28 of the writ petition, the present writ petition, that the issue of reservation was taken in those petitions which is not part of this writ petition. In spite thereof, well, there is an observation and finding arrived at by the Honorable Single Judge at para 15 of the impugned judgment that reservation policy was violated. Well, this is all regarding publication of panel reservation. Then I pointed out there is a complete mismatch of the candidates who were examined and the interviewers who were examined.
Yes, that you have dealt.
That I have dealt with. Well, so I need not repeat. One of the candidate, namely Salim Ali, was disqualified at the stage of verification or scrutiny. He could not have participated. He did not participate in the interview and aptitude test. But your lordship would, since we are dealing with that, just one more point to add factually. Out of these 21 common writ petitioners, 6 writ petitioners were examined in these proceedings. May I give the numbers? Kindly give me 1 second. If your lordship kindly takes the table once. Just the table, my lord, in my compilation 1, volume 1.
That list of dates you're showing?
Yes, man. After the list of dates, there is a table which I relied on. After the list of dates, man, it's the same, man. This is page 3 or page 4. Volume 1.
This one?
No. The table. Man, the table.
What?
But table demonstrating the mismatch. Now, my lord, kindly take this table. Since I am dealing with this, I have to conclude this.
Yes.
My lord will kindly take serial number 8, not 24 Parganas. Your lordship will kindly take Hemchandra Naskar. My lord has got that name. He was petitioner number 439 in Rabiul Sheikh. Kindly, my lord, for your lordship, I will include this in my note, but if your lordship wants to note that, your lordship may note that, subject to your lordship's consideration. 439 in Rabiul Sheikh. Then, my lord, kindly take.
Rabiul Sheikh was
before Justice, my lord, Mr. Justice Hiranmay Bhattacharya, where several writ petitions were decided, and the total number was around 900.
Yes.
Now, my lord, kindly take serial number 10.
Yeah. Selim Ali was rejected at the time of verification.
Sorry, my lord.
Selim at the time of verification
Rejected. And my lord, Ali Hassan Siddiq. Malda, there were two candidates who were, two petitioners who were examined. Ali Hassan Siddiq was petitioner number 72 in Rabiul Sheikh, and Salim Ali was petitioner number 73. He was disqualified, and his deposition has been recorded at page 489 of the paper book. Your lordship will find his deposition at page 489 of the paper book.
Yes.
Now, Miller, kindly turn over and take Dokhin Dinajpur, serial number 15.
Yes.
My lord, Sabina Yasmin, who is petition number 49 in the present writ, was petitioner number 262 in Rabiul Sheikh. Sabina Yasmin. My lord has got that, my lords?
Yes.
And Sham Sundar Das, same district, was petitioner number 213 in Rabiul Sheikh. So these are the 6 writ petitioners, common writ petitioners, who were examined by the Honorable Single Judge, and one of the petitioner was disqualified at the stage of verification.
Hasan Ali, Selim Ali, Sabina,
Ali came to us, Ali Hassan Siddiqui,
Selim
of the Yasmin. Well, lordship will find, I'm sorry, my lord.
Selim, Sabina, 5 petitioners.
Sorry, my lord.
5.
6. Well, may I give the numbers once again?
Hemchandra, Ali Hassan, Selim Ali, Sabina, and Sham Sundar.
No, Nur Huda.
That Nur Huda, Birbhum also.
He was also.
He is which petitioner?
My lord, petitioner number Nur Huda. Just, my lord, give me 1 second. Nur Huda is petitioner number 213. Was, I'm sorry. Was.
You said 213
Sham Sundar.
No, Sham Sundar is 286. I'm sorry, my lord. It is my bad. It's my bad. I'm so sorry. 262 is Sabina Yasmin, 286 Sham Sundar, and 213 Nur Huda.
Yes.
Well, we have included that petition in our compilation. Your lordship will find these names. And why we know that this gentleman, namely Selim Ali, was disqualified at the stage of verification, your lordship will find it in the affidavit in opposition filed by Mr. Chatterjee's client against the stay petition filed by the board, where it is, there is a table at page 15, at page 19, wherefrom it will be evident that Selim Ali, affidavit touch.
Very good. We accept your statement.
Yes, ma'am.
Yes. Now, which is your next point?
Malad, before I take your lordship to the next point, Malad, since I am dealing with this table, Malad, may I conclude with this table? Now, Malad, kindly take the table once.
You have showed us that from the Purbo Mednipur.
Yes, Malad, admittedly, just, Malad. Malad, I understand, Malad, I am not repeating. What I am trying to convey to your lordship, what I am trying to impress upon your lordship is that, kindly take for once, serial number 1, Jeet Sarkar.
Yes.
Malad, about 8 interviewers were examined. My lord, your lordship has got that? Malad, admittedly, in each subcommittee which took the interview and the aptitude test, there were not more than 3 members, 2 to 3 members. So these 8 gentlemen, they could not have interviewed Jeet Sarkar. A. Secondly, it is not apparent upon reading or examining or analyzing this particular nature of deposition that whether the interviewers were part of the same subcommittee which interviewed the candidates or the petitioners, the 26 writ petitioners. Secondly, there was no question put to these interviewers whether the other members of the interviewing committee or subcommittee put questions relating to aptitude test.
Yes.
It is not evident from anywhere, from the depositions.
Yes.
Lordship has got that. Now, my lord, coming back to my list of dates, kindly take, your lordship will kindly take this compilation. Kindly take the list of dates which your lordship will find at page 1 of the compilation.
This is in support of which argument?
This is in support of the argument at what stage of these proceedings, these proceedings, the plea that aptitude test was not taken was taken, and why? And why? What prompted the writ petitioners to take the plea which was not taken in the writ petition itself? At what stage? Malad, kindly take this date. First date, 6th December 2022. My lord has got that?
No, in the averment, there was no
allegation at all.
No allegation that aptitude test was not held. And you have showed us the orders of.
I want to show that what prompted them, and I will demonstrate in 2 minutes. 2 minutes of your lordship's time. My lord, 20th, 6th December, your lordship has got that? On 28/11/2022. My lord, kindly mark the date. My lord, kindly, if your lordship so pleases, kindly take note of this date. On 28/11/2022. 6th December, my lord has got that in the list of dates. That's the one of the orders passed by the Honorable Single Judge. On 28/11/2022, breakup score of the successful candidates was made available. This is, your lordship will find at page 77 of the writ petition. The first annexure to the writ petition. So at that stage, when the breakup score was made available, there was no averment or no allegation made in the writ petition that there was no aptitude test held, because breakup score contained everything, my lord, all the things. Now, my lord, why what this happened? Kindly take the next order. This is 20th December 2022.
Yes.
Your lordship will kindly take, for this purpose, kindly take, this is page 419. Kindly take only page 419. When this really happened, my lord has got page 419. 419 of the paper book. My lordship has a short compilation which was initially submitted. I think
419. Yes.
419. Kindly take 419. Kindly take, my lord, this second last paragraph. Kindly skip the first line, because, my lord, I will not read what is not necessary to be read. I direct Mr. Tiwari, learned advocate for the petitioners in these 4 applications, to supply similar tabular sheets to Mr. Vishwas, learned advocate for the board, by 22nd December 2022, and Mr. Vishwas will come up after verifying the marks of such petitioners and also along with the said 139 petitioners on 10th of January 2023. My lord has got that particular portion of the direction. Now, my lord, this direction was complied by the board on January 11, 2023. The date is extremely important. So on January 10, 11, 2023, for the first time, petitioners came to know how much they got in the aptitude test and the interviews.
So what was done on 28 November 22?
That was the successful candidates. They are unsuccessful candidates. 28 November 2022 is the...
So successful candidate
on
breakup
28
was
given. On and pursuant to the direction given by the Honorable Single Judge, my lord, the breakup
of unsuccessful was to be disclosed.
Not unsuccessful, only the petitioners. Not unsuccessful, restricted to the petitioners of 139 petitioners. On that direction was given on 20th December 2022, and my lord, it was actually made available to the writ petitioners on, my lord, January 11, 2023. Your Lordship will find again this.
No, then what do you want to say? January.
That is why
Huh.
on January 17th, so there were two orders passed in between 6th of December and 20th of December, where no allegation regarding aptitude test was made. 6th of December and 20th of December, no allegation regarding holding or not holding of aptitude test was made. So when they got the result of aptitude test, then they realized that they have failed. And then on 17th of January, for the first time, they made allegations that aptitude test was not held. And on that day, the Honorable Single Judge took deposition or took examined 7 of the petitioners and came to a conclusion from one that no aptitude test was held. So, my lord, the sequence is clear as to what prompted.
Yes, yes.
On the 17th of January, your Lordship will find.
You have shown us.
Your Lordship has shown.
Yes.
Instead of, so your Lordship has got the sequence as to when and why this allegation was made. Now, my lord, having regard to that, my lord, kindly now take.
So what is your next point?
Next point, my lord, I will answer the questions which I have framed. I have given a series of questions, my lord, the issues I have framed. One by one, I will answer. One I have already answered because panel publication, I have given a one page.
Yes.
Yes. The structure of arguments. There are certain, my lord, typos. My lord, kindly ignore the typos. Now, my lord, kindly my first.
Yes, yes.
So, my lord, the first one would
you
be
have to, that A you have finished.
No, my lord, I have not finished. I have finished part of A. Combination or outcome of interlocutory orders. I have not yet dealt with the issue that this is a case of perception subjectivity driven inquisitorial process. Now, my lord, having regard to this, my lord, the first authority, my lord, this has to be read with the second question. My lord, I will answer both. That whether a writ court, while exercising power of judicial review, my lord, this is not a PIL, while is exercising power of judicial review, could have invoked 165. And this is not classical cross-examination that the writ court can do, allow. But this is where the court steps into the arena and starts examining, my lord, the parties to the proceedings on its own to clear up doubts. So, my lord, first judgment I am going to cite on this issue would be Krishnalal Chawla. This is page 344. This is volume 2. Well, I have given 3 compilations. Volume 2, if your lordship kindly takes. Oh, volume 2. Thou? There are no. I am giving up. I am handing up. Dichi. Dana. Otana. Sorry. This is volume 2. This is going to be a pile of papers at the end of hearing. Well, so many trees are being burnt, used for no reason. Well, kindly take this compilation. Kindly take page 344. Kindly take, my lord, for once, paragraph 20, na? Kindly take paragraph 20 of this judgment. Murders got paragraph 20. Citation is, my lord, 2021.
Yes, got it.
5
Yes,
SCC. My lord, kindly take paragraph 20. It is said that every trial is a voyage of discovery in which the truth is the quest. In India, typically, the judge is not actively involved in fact-finding owing to the adversarial nature of our justice system. However, Section 165 of the Evidence Act, by providing the judge with the power to order production of material and put forth questions of any form at any time, marks the influence of inquisitorial process in our legal system. My has got that?
Yes.
So, this wide-ranging power further demonstrates the central role played by the magistrate in the quest for justice and the truth in criminal proceedings and must be judicially employed to stem the flow of frivolous litigation. So, my lord, this is where inquisitorial process is embedded in our judicial system. Now, my lord, now whether in a judicial review proceedings under Article 226, this kind of inquisitorial process could be undertaken or not, I am referring to Meerut Development Authority. This is volume 1.
That has been cited earlier.
I don't think so, because this is, I don't think Meerut Development Authority has been cited.
Yes, Mr. Dotto cited.
Mala 2009 6SCC Meerut Development has been cited. I don't think.
I may slip my, but I thought it was.
So many judgments.
To give us the page.
Mala, this is page 89, volume 1. There are 3. 2009 6SCC 171. I don't think, my lord, Learned Advocate General has cited this. But I will stand corrected, my lord. I don't think, my lord.
Which one is that?
Volume 1.
Volume 2.
There are 3 volumes, my lord. I have given only 3 volumes.
Are it a volume good? Eta.
Amar mone hai na eta side.
Is this the 3rd volume?
Malad, this is the 3rd volume where the orders, different orders passed. Yes, that is
You are
the
referring to volume 3, which
volume
is that?
2. Volume 1.
You have said that you are giving 4 volumes.
No, 3 volumes. 3 volumes.
This is volume 3 then?
Absolutely, my lord. My lord, we will mark it as volume 3 if necessary, my lord. My junior will do that at the end of hearing today. Volume 2, my lords have got that. Volume 1, my lord has got that. Kindly take page 89 and take, my lord, paragraph 67. পড়োনি তো এত জাজমেন্ট সাইট হয়ে গেছে না But this is a case where, my lord, tender was cancelled and it was decided to change the nature and character of the land, use of the land. That was challenged. And, my lord, kindly take paragraph 67 summarizes what is the scope of the litigation. Kindly take paragraph 68, 67 and 68. I will not read 67. I will read 68 and 69. Because my case before Lordship is that inquisitorial process cannot be undertaken at all in writ proceedings, in judicial review proceedings. My lord has got 89. May I read out, my lord, Mr. Justice Mitra? The impugned judgment illustrates the danger of judges wrongly, though unconsciously, substituting their own views for the views of the decision maker, who alone is charged and authorized by law to exercise discretion. With respect, we find that the High Court virtually converted the judicial review proceedings into an inquisitorial one. The way proceedings went on before the High Court suggests that as if the High Court was virtually making an inquiry into the conduct and affairs of MDA, in a case where court was merely concerned with the decision-making process of NDA in not accepting the offer or tender of AMS in respect of disputed plot on the ground that the offer made was less than the reserve price fixed by MDA. We express our reservation in the manner in which High Court dealt with the matter. The High Court went to the extent of holding that there was a concluded contract between MDA and MS. Of course, Learned Senior Counsel so-and-so did not support the findings. So, this inquisitorial process, and since 165 is an integral part of the inquisitorial process, this could not have been done. Where it could have been done, my lord will kindly take Manohar Joshi. This is, my lord, volume 2, page 61258, and it is 2012 3SCC 619. Kindly take paragraph 185.
Page, volume 2, page?
Volume 2, page 258. I will trouble your lordship only with one paragraph. Paragraph 185. 258 বলুন 258 এটা ভলিউম 1 না ভলিউম 2 রে ভলিউম 2 তো 258 is the running page, my lord, the paper book page. And my lord, I take your lordship to 328, that is the running page. Now my lord, kindly take page 18, paragraph 185. My lord has got that, my lord. Public interest litigation is not in the nature of adversarial litigation. My lord has
paragraph
185. Public interest litigation is not in the nature of adversarial litigation, but it is a challenge and an opportunity to the government and officers to make basic human rights meaningful as observed by so and so in Bandhua Mukti Mitra. By its very nature, PIL is inquisitorial in character. Well, ironically, this writ petition contains a paragraph that this is in the nature of PIL. Had it been a PIL, again, my lord, I have my own reservations. This kind of inquisitorial process could have been taken, but that is also subject matter of dispute. But whether in a judicial review proceedings, this kind of inquisitorial process, my lord, there is no doubt about it that 165 is an inquisitorial provision, could have been undertaken. The answer would be, in my respectful submission, in the negative.
Yes.
My lord, I have tried to summarize what was held by Lord Denning in Jones versus that's the kind of, my lord, the pointer. My lord, may I just give the summary? Your lordship will find this Jones judgment in volume 1, page 53 to 63. And I will not trouble your lordship with the judgment at all, because this has been cited by Mr. Mitra, Mr. Jayanta Mitra, as well as by Mr. Aninda Mitra. But my summary would be like this. Court cannot investigate on behalf of the society. This is the first finding or the first limitation imposed in Jones. Court cannot call witness whom he thinks might throw some light on the facts. 53 to 63, my lord. Court cannot call witness whom he thinks might throw some light on the facts. Pausing here for a moment, the order dated 6th of February 2023, the Honorable Single Judge says in its order, in the order, that I think I have to get some facts from the 5 districts, from the interviewers of 5 districts. So this is against this principle. Court should be content with the witness called by the parties. That did not happen in this case. Court may ask questions to clear up any point that he has been overlooked, and court cannot assume the role of an advocate. So, my lord, all the parameters, or all the, my lord, this is the plinth and amplitude of the power to be exercised under 165. And in my most respectful submission, we due respect to the Honorable Single Judge, my lord, this has not been done. This has been violated. And these forms, my lord, what should I say, the foundation of this judgment.
Yes.
And the conclusion that there was scam, etc., is also, my lord, a conclusion which was driven at on the basis of this inquisitorial process.
Yes.
So, my lord, my second, my lord, these are the 3 judgments I cited right now. My lord, Jones has already been also been followed even in the recent. I'm not citing the judgment, but that is in the compilation. Lordship may kindly take note of Muhammad Abdul Wahid versus Nilofer, 2024 2 SCC 144 at para 3. Well, I am not going to read that. 2024 2 SCC para 144 at page 144 at paragraph 3.
Yes.
Then, my lord, I take your lordship, my lord, whether this kind of fact-finding exercise could have been carried out or undertaken by the Honorable Single Judge. My lord will But I will also answer the scope of aptitude test later on. Now, in this fact-finding exercise, what was the nature of fact-finding exercise? This is very important. Malad, 3 basic questions were put to the candidates. Malad, what were the nature of questions? What were the questions? May I take your lordship? I have just tried to summarize the questions which were put. What, according to you, is aptitude test?
If 165 domain is restricted by your argument, question of
No, my lord, my question is that my next argument would be that by judicial interpretative process, if we take the judicial interpretative process to that extent, when a particular expression has been defined in an act, in a regulation, that has been defined, my lord, aptitude test, my lord, through this process, no words, no concept, or no words could be added or subtracted in those processes. What has been done, as if the blackboard has not been used, if the classroom demonstration has not been given or taken, then there was no aptitude test at all. That is the conclusion arrived at by the Honorable Single Judge, and that is evident from all the depositions. When we have read all the depositions, 3 questions are very pivotal. What, according to you, is the aptitude test? Well, kindly take it from me, your lordship can take note of, because was there any blackboard? Were you asked to do anything on the blackboard or using any model in the blackboard to explain anything?
Yes.
As if only and only when blackboard is used, and if only when a candidate is proficient in using the blackboard, he would be eligible for the post of primary teacher. Now, Miller, now having regard to this, Miller, kindly take the definition of aptitude test, which your lordship has read. But
taken to that.
But Miller, the aptitude definition of aptitude test is clear, is unambiguous.
That is your argument, that you cannot add something to the definition.
Yes, Malad, that is what I am on. So, Malad, my question is that my submission would
back to be an this
this
investigation.
Malad, why I am making this submission, because for the reason that I am taking this submission as my alternative submission. Suppose your lordships are not with me in the first point, then I have to demonstrate before lordship.
We shall ask you, Mr. Mujumdar.
Malad, this is ex abundanti cautela. So I have to do that, my lord. Kindly allow me to do that.
We cannot just stop asking questions.
No, you can. Definitely your lordship can ask,
so
obviously.
That you
I invite your lordship to ask as many questions your lordship
exactly. So we want to hear what is their stand.
Your lordship will definitely hear the stand.
Basic argument we accept. Application of 164, how you will do it in one sort of litigation.
Yes. Malad, only for the sake of completeness. Only for the sake of completeness. Malad, kindly take 2 judgments. That is one thing interesting, Malad. Malad, this concept of classroom demonstration was for the first time introduced in National Education Policy 2020. Malad, we have included the relevant part of the National Education Policy 2020 in our compilation, which your lordship will find at page 377, which is volume 2. Kindly take that one. Whether 5.4 na? Recruitment and 377, volume 2. Kindly take.
Yes.
Teachers' eligibility test will be strengthened to inculcate better test material, both in terms of content and pedagogy. The tests will be also extended to cover teachers across all stages, so and so.
Which paragraph you are reading?
Paragraph 5.4 of the NEP, National Education Plan 2020.
Yes.
For subject teachers, suitable TET or NTA test scores in the corresponding subjects will also be taken into account for recruitment. to gauge passion and motivation for teaching, a classroom demonstration or interview will become an integral part of teacher hiring at schools and school complexes. So, my lord, even in NEP 2020, classroom demonstration was not made mandatory. Even, my lord, some kind of interaction with the candidates is treated to be sufficient. And the honorable single judge, in all the depositions, your lordship will find that the first question is that, or the main questions are that, was there any blackboard? Did you use blackboard? Did you where there was where you
the national education policy includes class demonstration and
or kindly take my lord, or interview. And this was introduced only in 2020. And this recruitment process was undertaken in 2016. Interview, I mean, the appointment letters were issued in March or February 2017. So, my lord, this is what it stands. And, my lord, these particular words, this through judicial interpretative process, this cannot be done. Kindly take, my lord, these two judgments. My lord, first one is in my compilation, that is Kotak Mahindra Bank 2022 9 SCC 186. This is at page 8 of volume 1, right? Volume 1. And your lordship will kindly take only paragraph 76 and 77. '76, my lord, Muhammad Shahabuddin was referred to. 76 and 77 is the summary. It is more than well settled that when language of a statutory provision is plain and unambiguous, it is not permissible for the court to add or subtract words to a statute or read something into it which is not there. And, my lord, in my most respectful submission before lordship, well, this is what has been done. Because if there is no blackboard, no aptitude test was held.
Yes.
My lord, this was, my lord, the pointer. Now, my lord, next one, your lordship will kindly take. Next, in this line, I'm just giving the citation and the paragraph. No need to read. My lord, it is the judge's case, Deokinandan Agarwal, 1992 supplementary SCC 1 323, which your lordship will find at page 41 of volume 1. 1992 supplementary 1 SCC 323 at para 14 volume 1.
Yes.
Then, my lord, the next one, the next proposition which I want to canvass. So, my lord, I have dealt with 165, I have dealt with interlocutory order. I have also dealt with, my lord, whether the evidence taken by the court could be the basis of this kind of order of cancellation of appointment of 32,000 untrained candidates. But I have demonstrated from the table and also from the deposition what was the nature of questions being asked. And also, my lord, there is a complete mismatch between the candidates who were examined and the interviewers who were examined, that this evidence is not, I should not use the word sufficient, it is not, it is not at all evidence for the purpose of quashing the appointments of 32,000. The judgment, though, my lord, a process of taking evidence was undertaken by the court, but, my lord, the judgment is based on no evidence. My lord, kindly take for once. This is Om Prakash Chautala. Sorry, my lord, kindly take first. I'm sorry, kindly take for once. This is AIR 1993, page 169. Your lordship may kindly take. This is a full bench of Calcutta High Court. AIR 1993, Calcutta 144. The relevant paragraph starts from paragraph 100 onwards, but I will take your lordship directly to para 112 and 115. Oi, Ratan Lal. My respectful submission before your lordship that there has been, kindly take 115. Kindly take act. This is a judgment for the proposition that there has been complete failure for my lord perverse treatment of evidence.
Which para you are showing?
I am showing from, I am giving your lordship the paragraphs 91, 93, 101, 102, 104, 107. Then, my lord, 108, 109, 110, 112. 112 is relevant, my lord. I will only read relevant paragraph. Kindly take page 112, which is at page 206 of the compilation.
Yes.
The perversity of approach being vitiated by reliance on irrelevant materials. Page 1, paragraph 112, my lord.
112?
Page 206.
You're reading from the middle?
No, my lord, yes, I'm reading from the middle. I'm not troubling your lordship.
Where you are there? Which line you said?
My lord, the
perversity of
the approach. The perversity of the approach being vitiated by reliance on irrelevant materials or exclusion of relevant material in reaching the inference or inference on no evidence is a substantial question of law.
Yes.
The next one in this line would be, my next submission would be,
Yes.
allegations of malafide are serious in nature and they essentially raise a question of fact. It is therefore necessary for the person making such allegations to supply full particulars in the petition. If sufficient averments and requisite materials are not on record, the court would not make a fishing and or roving inquiry.
Yes.
Mere assertion, vague averment, or bold statement is not enough to hold the action to be malafide. It must be demonstrated by facts. Moreover, the burden of proving malafide is on the person leveling such allegations, and the burden is very heavy. Then they refer to Royappa. This judgment has been followed in a service matter, that is Chandra Prakash Singh versus Chairman Purbanchal Gramin Bank. It is 2008-12 SCC 292 at paragraph 30 and 34. This is at page 155 of the compilation. 12 SCC 292 at para 30 and 34. Kindly take 30. This was a matter relating to promotion. Kindly take page 30.
Yes.
All that has been alleged in paragraph 11 and 14 of the writ petition by the appellants reads as under. That the written test was held on such and such date, which was conducted by the opposite party 10, who was the officiating chairman of the bank at that time. That it was specifically mentioned in the above mentioned complaints that opposite party number 10 was making grounds for promoting his real brother and his cousin, namely Syed so and so, who are already employed in the bank as clerk cum cashier, and he wanted their promotion to officer scale 1. The above extracted allegations are absolutely vague, indefinite, and did not contain sufficient material as required under the law in support thereof. The appellants have not established on record that the respondent number 10 so and so, the then chairman, was an instrument in getting his brother and cousin through in the written examination, and later on it was under his influence that the selection committee has selected his two relatives in the post in question. Para 34. After dealing with several judgments, including, my lord, this judgment which I have referred to, kindly take. Thus, as a proposition of law, the burden of proving mala fide is very heavy on the person who alleges it. Mere allegation is not enough. Party making such allegations is under the legal obligation to place specific materials before the court to substantiate the allegation. There has to be very strong and convincing evidence to establish that allegations of mala fide specifically and definitely alleged in the petition, as the same cannot merely be presumed. The presumption under the law is in favor of the bona fides of the order unless contradicted by acceptable material. But in this case, there is no allegation against, my lord, these 32,000 candidates specifically. We have filed our appeal. There is no counter to the effect that these 9, I am representing about 1,600 candidates, that these 1,600 candidates were directly involved in, my lord, this kind of job rigging.
Yes.
Now, my lord, now what we have done, Mr. Chatterjee has given filed an affidavit, where, my lord, we will find the number of the last empanel candidate with respect to a particular category, and, my lord, the petitioner's position with all the breakups. What we have done, what my learned junior has done, unbelievable task he has done. Kindly take this chart. We will circulate it. This is based on their affidavit.
Whose affidavit?
My lord, 2 copies.
Whose affidavit?
My lord, Mr. Chatterjee's affidavit to the stay application filed by the board. Affidavit in opposition.
Mr. Chatterjee.
Mr. Chatterjee's affidavit in opposition to the stay application filed by the board in one of the writ petitions. With one of the writ petitioners. Well, I promised your lordship that I will hand out colorful charts. Well, at least that much I have lived up to. Rest I don't know. Kindly take one by one. Konta dekhao bol. Well, kindly take LEC. Well, I'm sorry, my lord, your lordships have got that. LEC is the last empanel candidate.
Yes.
Then, my lord, your lordship, that is, my lord, that is printed in red. LEC is the last empanel candidate. Now, my lord, kindly take. This is with respect to this last empanel candidate. The petitioner who would be under consideration would be petition number 37. Kindly take the marks.
No, what argument you are advancing?
Well, I am advancing the argument that the score obtained in this aptitude test did not have a telling impact as alleged or at all. Even some candidates who are petitioners before lordship scored quite highly in the aptitude test, as would be evident from this chart. And I will demonstrate one by one. Kindly take from LEC. Well, I will not read everything. LEC 37. Well, how much did the last time panel candidate got in aptitude? 1.25. Malad has got that? Malad, Mr. S.C. Chakraborty?
Yes, which one you're
The first one. Kindly take the first one in the table. The last time panel candidate got 1.25. This is opted district 3. The petitioner with corresponding to that candidate got 1.30. How much the petitioner secured in the TET and the other marks? 14.107 was secured. 14.107 was secured by LEC, last time panel candidate. We have added up. We added up the TET score, Madhyamik score, HS score, and TET plus MP plus HS is equal to 14.107 in the case of last time panel candidate, and the score of the petitioner number 37 is 9.087. And they say that this is illegal. Now
Last
this
panel candidate got 14.107.
107. Well, we have just added.
And petitioner number 37 got
9.087. Well, this may be this way or that way, but that is not determinative. Kindly take the second one. This is, my lord, last time panel candidate is one Tomalika Kundu. Now, my lord, kindly take the marks TET plus MP plus HS marks obtained by Tomalika Kundu is 11.796. They scored equally in the aptitude test 1. And my lord, obviously, my lord, the other candidate, the petition number 121 secured 11.606. And my lord, 89, petition number 89 secured higher than the last time panel candidate in the aptitude test. Next, my lord, this is classical. Third one. Now, my lord, this candidate scored 15.179 in the combined score of TET plus MP plus HS. And my lord, aptitude test, he scored 2.50, and petition number 48 scored 3, and petition number 1 scored 49 scored 1. It would have hardly made any difference because the marks obtained in the combined score is 15.15179. I say that this may be otherwise also, but this does not indicate that there has been scam as alleged or at all, so far as my petitioners are concerned, my appellants are concerned. Now, my lord, kindly take the fifth one. Fourth one, your lordship can also take, no difficulty. This is the reverse case, 10.639. My lord, in this case, the last time panel candidate scored 9.5. The petition number 84 and 89, 847 scored 1. But they could not secure their position in the panel. This is otherwise. Second, third, fifth one. Here, my lord, the successful, the last time panel candidate scored much more than the petitioners in the writ petition, 12.93. And he scored 1.5 in aptitude test. Petitioner number 64 scored 3.66. Petitioner number 58 scored 2. Petitioner number 115 scored 1. Petitioner number 1.
All these petitioners were in the panel, found their position in the panel.
No. They were not in the panel. This was the disclosure, on the basis of the disclosure which was made on 11th of January 2023. They got the breakup. They got the breakup from that disclosure. They are not questioning that document. Their case is based on that breakup. Kindly take, my lord, just kindly take. This is the part of their affidavit. My lord, it will be difficult for. Na, Josh Saheber kaje ekhuni bar kore difficult na. My lord, kindly take the affidavit ta din to.
No, very good, very good. We are taking.
My lord, your lordship will find on 11th of January, this data was provided to the petitioners. And your lordship will kindly take the score. This may be that way or this way. It doesn't matter. One may perform badly in interview, one may perform good in interview and in aptitude test. Then, my lord, kindly take the next one. My lord, again, the sixth one is a reverse case, where, my lord, the last impanel candidate scored more. Seventh one, my lord, kindly take the last impanel candidate and the petitioner scored equally in the interview and aptitude test.
Yes.
Similarly, for the last but one, Malak, kindly take the score of the second last in this page. 14.851 is the TET plus MP plus HS. Got only 2 in the, my lord, this aptitude test. And, my lord, petition number 108 got 3.
Yes.
The last one, my lord, in this page, some Firoz, my last impanel candidate got 13.134.
He got more marks than the selected candidate in aptitude. One.
No, not at all.
Yes,
Bengali, Hindi.
Your
My lord, kindly take, my lord, may
the chart.
My lord, I have failed to explain one thing. The lordship kindly takes the chart. Kindly take the category, the table, the first, the rows and rows.
Yes, yes.
Your lordship will find there is one impaneled category. Your lordship.
Medium Bengali.
Well, it is the race. First, kindly come to the impanel category. In the chart at the top, there is one category, namely impanel category. My lord has got that. At the top, petitioner number, opted district, medium is Bengali. Medium is Bengali, my lord. Not subject Bengali, my lord. Medium is Bengali.
Can we find the subject?
My lord, subject in primary, there is no question of subject. It is primary, my lord. It's not subject-oriented lists. Kindly take medium is Bengali, my lord. I have failed, my lord.
So
this
it is on the basis of different medium in the
different medium.
also.
Hindi also.
So we have 3 mediums: English, Bengali, and
English
Hindi.
is not there. English is not there.
That is the school is.
Old Chiki is there. Old Chiki is there. Nepali is there. But this is why, my lord, the honorable judge, single judge, got annoyed that the teachers don't know even the English, the language.
So this chart which you have prepared is only in respect of Bengali medium.
No.
Bengali, Hindi.
Petitioners.
Medium.
My lord, kindly
This
take
chart which you are showing.
I am showing. This is with respect to the 139.
No, this is pertaining to the medium of Bengali you have indicated.
Right.
Here.
The 139 petitioners who are before your lordship, the petitioners, they are all Bengali medium candidates.
Very good. You tell us that.
Yes. And Hindi also. Hindi একটা দেখাও তো।
No, not that. All are not Bengali.
No, correct. হিন্দিও আছে না?
So this
আসছি দাঁড়া আসছি তাড়াহুড়ো করিস না। পেজ 3 পিটিশন নাম্বার কোথায় আছে? মানে লসি will kindly take page 3. এই নেপালি আছে এখানে কি বলছে?
So there was a panel was pertaining to different mediums. What was the distribution?
Different medium, different category.
Different categories, ex-servicemen, SC, ST.
No, kindly take one. That is why I want to clear. This category, the empanel category, though the empanel category is para-teacher, ex-serviceman, para-teacher, these are the category under which the posts were filled up. But these categories, sufficient number of candidates were not available against these categories, and that is why respective SC categories, respective OBC categories from the general pool, I mean not general candidates, from the general pool were accommodated against these particular empanel categories. Suppose there was a post for 100 posts were meant for these para teachers.
Yes.
80 filled up. So remaining 20 were filled up in this way. All of them. So far as the read, and that is provided in the 2016 rules itself. Rule 8. Well, I will place.
You are citing this chart for showing the court that many petitioners, in fact, in aptitude, has obtained more than the empanel candidate.
Yes, last empanel candidate.
Now take us to the next point.
Yes. Kindly take for once page 3.
Yes.
Well, I will just give it some random numbers. Miloshi will find LEC under which 25. This is a Hindi medium candidate.
Which LEC?
LEC 09 Hindi. Third new one. Hindi. Then my lord has got Hindi. After Bengali, again Hindi. So whatever where the medium, the petitioners participated with respect. With respect to that, last empanel candidate we have given. And my lord, your lordship will find in most of the cases, my lord, the last empanel candidates secured much more in the combined score, that is TET plus MP plus HS. Not in all cases. I am making it very clear. In most of the cases. My junior insists, my lord, for his own satisfaction, may I place one page? This is classical. One page. My junior is so insistent.
If junior says place 100 pages,
no, I can't. Only one. That is why I picked up only one. Page 4. The first one. That is Showman Kundu is the last empanel candidate, secured 2 marks in aptitude test. And my lord, petitioner number 131 secured 5 plus 5.
Yes.
131. My lord, your lordship has the chart. My lord, your lordship will obviously go through this chart. Now, my lord, I come back to the core points. Now, my lord, kindly take আর কি জাজমেন্ট বাকি আছে? বাকি নেই না? কোনটা বল? 1 minute. Period বলা হয়ে গেছে 1 2. Yes. Only one judgment or 2 judgments. Kindly take Om Prakash Chautala's case. The name itself is very tainted. Kindly take.
Yes.
Kindly take Om Prakash Chautala's case, which your lordship will find. Why I am saying this? Page 112. Because my page 112 of the compilation. My respectful submission. Sorry. I am very sorry. 2014 5 SCC 417. I am referring to para 19.
Yes, para 19.
Well, kindly take para 19. It needs no special emphasis to say that a judge is not to be guided by any kind of notion. The decision-making process expects a judge or an adjudicator to apply restraint, ostracize perceptual subjectivity. That is my first, one of my issues which I have raised. Make one's emotions subservient to one's reasoning and think dispassionately. He is expected to be guided by the established norms of judicial process and decorum. A judge may have rhetorics, but the said rhetoric has to be dressed with reason and must be in accord with the legal principles. Otherwise, mere rhetoric, especially in a judgment, may likely to cause prejudice to a person, and the courts are not expected to give any kind of prejudicial remarks against any person, especially so when he is not a party before it. In that context, the rhetoric becomes sans reason and without root. It is likely to blinden the thinking process. A judge is required to remember that humility and respect for temperance and chastity of thought are at the bedrock of apposite expression. In this regard, may be profitably refer to my Lord Justice Frankfurter's observation. Well, for the highest, this is what I'm on, for the highest exercise of judicial duty is to subordinate one's personal pulls and one's private views to the law of which we are all guardians. And those impersonal convictions can make our society a civilized community and not the victims of personal rule. As I've indicated, my lord, this was kind of, my lord, perception subjectivity driven inquisitorial process.
Yes.
Along with this, my lord, kindly take, my lord, this similar line, but my lord, this is again page just 1 minute, page 249. This is 343 volume 2, na? Volume 2, 249 volume 2. This is, my lord, the US Supreme Court judgment, where, my lord, Justice Frankfurter again recused from a matter, recused himself. Kindly take paragraph 33, which your lordship will find starting at page 253. Sorry, 343 bollam, so 343 US 451. Para 33.
Yes.
The judicial
the same principle.
Same
which you are arguing.
Absolutely. Absolutely.
Yes.
And my lord, this has been followed by this US Supreme Court has been followed by the by our Supreme Court in 1987 4 SCC 611238.
Page. Which
Yes.
page in the volume?
I'm sorry, my lord, I should have pointed it out. Kindly give me a second. This is page 238. But my lord, kindly allow me to read this one.
Yes. Which paragraph?
My lord, paragraph 20. 15 to 20, 25 to 28, but 15 to 20 would be most relevant.
Para 20.
Para 20, this is Justice Frankfurter's observations being quoted. This is again, my lord, on that issue only. Only paragraph 15 I may add. This is the submission. Only the second limb of the contention is that as to the effect of alleged bias on respondent number on part of respondent number 4. The test of real likelihood of bias is whether a reasonable person in possession of relevant information would have thought that bias was likely, and is whether respondent number 4 was likely to be disposed of disposed to decide the matter only in a particular way. There is a concept your lordship has dealt with in so many matters. There is a concept of confirmation bias, which is akin to when witness action is taken. But this principle of confirmation bias is also embedded in our judicial system. And this is what I am on. It is like, my lord, there is a surrounding circumstance that scams are happening everywhere. So this particular recruitment is also tainted with scam. And there is no analysis that there is a distinction between tainted and untainted in the judgment. But these
yes.
Well, these are mainly my submissions. But right, one more judgment. This is on a different footing altogether. kindly take, my lord. This is Srinivas K. Gaura, Volume 2, where select list was not challenged. This is not Sadanand Hello. Sadanand Hello, my lord, Mr. Bandopadhyay, my learned advocate general, they have all placed. Kindly take, my lord, Srinivas K. Gaura. Page 228. This would be volume 1. Correct. Volume 2. 2022 1 SCC 49. Relevant paragraphs would be paragraph 25, 26. Correct. Kindly take 25 and 25.
Yes.
The division bench of the High Court set aside the appointment of the appellant on 2 grounds. First, the marks provided for candidates at the interview and for experience category were held to be arbitrary. This is like aptitude test. To arrive at this conclusion, the division bench referred to the entire select list and found alleged discrepancies in the allotment of marks for experience and a pattern where all the selected candidates were given higher marks for experience and at the interview. Second, the division bench held that the advertisement issued by the first respondent did not mention the criterion of work experience, but only provided the minimum educational qualification. Thus, it is held that the rules of the game were changed after the process had started. The appointment of the appellant was set aside by the division bench by finding that the additional selection criteria devised and the marks provided in those criteria were arbitrary. As observed earlier, the selection list was not challenged by the respondent. His only ground for challenge was that he had to be selected since he was more meritorious. That is the exact case of the petitioners before lordship.
They have challenged the panel.
They have not challenged, my lord. They want to be treated similarly. That is their prayer. Therefore, determining the legality of the selection list and perusing the selection list to determine whether selection of the appellant was arbitrary or erroneous as the division transgressed the limits of challenge in the writ petition.
Yes.
Well, one more judgment, that is whether a judgment can be rendered on the basis of conjectures and surmises. This is at page 361, volume 2. Paragraph 361. Volume 2, 361. I am giving the citation to my learned friends. 2009, 14 SCC 480. 480. 32. 32. Relevant. Kindly take paragraphs for 32, 46 and 47. I'll take your lordship directly to 46.
Paragraph
46, my
46.
46, my lord, at page 370.
Yes.
The manner in which the High Court has dealt with the issue, in our opinion, cannot be appreciated. A court of law must base its decision on appreciation of evidence brought on record by applying the correct legal principles. Surmises and conjectures alone cannot form basis of a judgment. And 47 is on identical lines. So that was dismissed. So this is my sum and substance. I would also beseech your lordship. I do not know, but I am apprehensive that the judgment rendered in the case of SSC matter by Supreme Court may be pressed into service by the others, by my learned friends. That judgment is distinguishable, and we will make our submissions on that judgment if cited at the time of reply.
Yes.
I am so grateful, and I am extremely sorry to detain your lordships for so long.
Yes, next, who is coming? Who wants to? Thank you, Mr. Ojumdar.
Great.
Yes.
Item number 48.
Give the number of the
MAT number 1387 of 2023.
Just a moment. MAT
1387 of 2023. There are 392 appellants.
Yes.
All untrained.
Yes.
And their leave to appeal application was allowed on 4th of September 2023.
Yes.
And I'll be precise, my lord. I'll not take much time, but I'll start with paper books in my lord board's appeal, that is my lord MAT 873. My lord, you will kindly take the volume 1.
You said you all are untrained. Everybody is untrained. Do I
Yes,
got?
I am just untrained general, right?
Yes.
All are untrained. But if you kindly keep it in mind, my lord, these entire my lord, cancellations of my lord, selection process relates to untrained candidates.
Yes, yes.
Now,
so you mentioned untrained, no? So I was in doubt. Anyway, yes. What do you want to show?
Yes. Now, you will kindly take there was no amendment to the writ petitions, which was originally filed, that remains.
Yes.
No amendment application filed. The what has been my lord, stated in the writ petitions, that was only affirmed by the petitioners and took responsibility thereof. Now kindly take the writ petition once, my lord. It's in page, let's say, start from page 1. Can we take page 36, the paragraph starts.
Yeah.
Paragraph 2, I'll be first showing that your petitioners are unemployed, educated youths of West Bengal. They do not have any regular permanent employment in spite of having qualification.
Paragraph 6.
Paragraph 2, page 36 of the paper book.
Yes. Yes,
yes. They do not have. Your petitioners have common cause of actions and they have decided to file this case jointly. The petitioners are praying before this court for exemption of the court fees. Then, my lord, documents of the petitions number 1 to 10 and documents of the petitioner number 130 to 140 showing they are TET qualified are being annexed here too and marked with letter P1.
Yes.
Then, my lord, paragraph. So, some of the petitioners, as they have pleaded, were TET qualified as per their own pleadings. Pleading. As per pleadings, they didn't say that they are all qualified, but in fact, as my junior said, they are all qualified, but they said only 10, 20 of those petitioners were TET qualified. Your petitioners, next paragraph 3. Your petitioner state that on 19th October 2002, the West Bengal Board of Primary Education published notification for recruitment of assistant teacher in primary school. It is needless to state that there were huge irregularity in TET 2012 and several cases were filed.
Yes.
We are not concerned with TET, but they cited it. In spite of irregularity and illegality, 18,000 teachers were recruited and the government of West Bengal gave one exemption to the aspirants of TET 2012 that the aspirants of TET 2012 can sit for the next examinations and in that case they shall be exempted from paying any fees for the examinations. Now, just pausing for a moment. These, most of the petitioners, they appeared in 2012 recruitment process were unsuccessful. Then they participated in 2014 TET and 2016 in recruitment process. They became also unsuccessful. It was not stated. Now kindly take Malad.
Yes.
Paragraph 4. Your petitioner states that on 12 November 2014, National Council for Teachers Education has published a notification such and in that notification, qualification and other procedures for recruitment are prescribed. Now, your petitioner states that on 9th April 2015, Ministry of Human Resource Development, Department of School Education and Literacy Government, extending some relaxations to the state of West Bengal till 31st March 2016 with certain conditions. Now, if you lordship sees annexure P4, it says that this extension was given because the minimum qualifications is TET qualifications and the DLE, the training qualifications. Now, so far as this extension was allowed with respect of that the untrained candidates can be recruited up to 31st March 2016 and they proceeds on the basis. What happened thereafter, I'll show. What the writ petitioner proceeds on the basis that the last date for appointment of untrained candidate was 31st March 2016.
No, that they have not said. They have said.
Yes, that is the specific case. Your relaxation,
relaxation was up to March 2016.
That case was also that up to I'll show next. Then paragraph 7. I'll show certain paragraphs.
Is it their case that you having been appointed in March 2017?
2017, so we are entitled.
Stand,
So we have been given special privileges, so they stand on the same footing, they should be given the recruitment.
Right. They are not saying that appointment is bad because within that period they have not.
That twofold. One is last cut-off date was 31st March 2016. It could not be extended. Then is since the state government,
But
board
prior
has
to that, the selection process started.
selection process.
31st March.
No, there are two processes. One is state process for
State
state.
is of
2014. Selection process started in the present case September 2016. The notification came in September 2016.
Advertisement came.
Advertisement.
Recruitment rule was of 2nd of March 2016. That is prior to 31st March.
Prior to 31st, but the process was started on September 2016. What happened, Malad? This date was subsequently extended till October 2017.
This 31st March?
Yes.
Where do we find that?
Malad, that. Auto volume kano? Duto, duto.
Achha, you tell us up to when it was extended.
Malad, 10th October 2017. That was the last date, Malad.
Prior to that advertisement published.
Long, even prior to the appointments, after the appointments given, prior to that date, all appointments given.
Prior to October 2016.
2017.
Extended till October 2017.
17. I'll show that. Take it from me, Malad. Show. Malad, there was a judgment of the landed single judge permitting, Malad, even after the lapse of this period, permitting the state government to carry out the selection process. No appeal. Malad, ultimately, the Ministry of Malad, HR, Human Research, and they.
No, Mr. Gondo, is it their argument that since the date expired on 31st March?
I'll show from the pleadings itself.
Sure.
I'll just going on.
Yes, we are in paragraph 5.
Paragraph 5.
Yes, then which paragraph you
Then
want?
Paragraph 6, they said this 14th July 2015, Government of West Bengal has published notification. Then 7th state examination held. Paragraph 9.
Yes.
Your petitioner states that on 14th of September 2016, the result of TATE 2014 was published, but no merit list and scorecard was given to anyone. On 26th of September 2016, notification was published for appointment of primary teachers for TATE 2014 to fill up 42,949 vacancies. Everyone said that out of this, 32,000 and something is for untrained and the rest are for trained. Now, these are the total vacancies. In that notification, it was clearly stated that the candidates with minimum qualification as specified in MHRD will get preference, and after the eligibility candidates with relaxed qualification may be good. It is needless to mention that MHRD gave relaxation only till March 2016. And in spite of that, the board notified that the candidates who do not have training will be considered too.
This is the only line they have used in the entire petition.
Now, what they have used, I'll show, Malad. I'll just read, I'll not touch anything. I'll just go on the writ petitions. But what is my first point? First point is, Malad, under any circumstances,
yes,
under any circumstances, an untrained candidate could be appointed up to 10th of October 2017.
Yes.
Let's keep it in mind. And according to them, it was up to March 2016. 10th August, I'm sorry, 10th August 2017. Up to.
Yes.
In the present case, my lord, all appointments of untrained teachers, were made in between February to April 2017. There was no other appointment for any untrained teachers, my lord, after April. These dates are vital, my lord, because to show that the REET was not maintainable in 2023 or 22. Also. My lord, up to 10th August 2017, an untrained candidate could be given appointment in the state of West Bengal. All appointments which have been given in the present case was in between February 2017 to April 2017.
Yes.
My lord, according to their statement, they participated in the interview process. My lord, there was no contemporaneous documents, my lord, not even a letter written by any of these petitioners, my lord, either to the board or to the district primary school council, saying that you see this interview was contrary to the rules. My lord, no aptitude test was taken.
Yeah, that has been argued. That this
No,
is
not a single document. Now, this was not there. Now, for the first time, they came and in the REET petition.
in 2022.
2022. Now, their prayer in the REET petitions, I will be coming back to their paragraphs. Kindly take their prayers.
Yes.
47.
Yes. Yes.
First prayer, to act then. To direct the authorities to file report disclosing the names and numbers, rank categories of all non-trained candidates who have been recruited till date in primary school from TET 2014. Then, to direct the authorities to treat the petitioners equally with the non-trained candidates who have been recruited by the board after expiry of the relaxation given by the MHRD. On 9th April 2015, that was their case. I had shown MHRD gave relaxation as per them is 31st March 2016. Now, my lord, it cannot be, because the state government or the board has no independent authority under any circumstances. Even if any appointment given, they do not get any benefit from that appointment. If any untrained teacher was appointed after the cutoff date, they could not have acquired the training, because the training was for them up to 18 months. That completed in 2019, the last date of obtaining training. That also stood expired. So, their case in 2022, it is not maintainable at that time. May I clear to your lordships?
Yes.
In 2022, none
have
of the
already-
prayers could be
You
granted.
have already become trained.
Yes.
That is what Mr. Pratik Dhar argued.
No. Question of training, whether
under Rule 3 provides
under the MHRD guidelines and the rules, my lord, only those persons who were appointed prior to 10th August 2017,
Right.
they could have obtained this training.
Yes, yes.
And for training, it was 2 hours, instead of 2 years training, they were given 18 months period. That was the relaxation given by the ministry. Now, nobody can claim appointment, my lord, after 10th of August 2017, pursuant to 2016 recruitment process. Even the state has no power, even the board has no power, even the court has no power. Forget about the learned secretary, even the division bench has no power to give appointment after 10th of August 2017.
Yes.
So delay is another thing altogether. I say, my lord, in 2022, this REET petitions in the present form was not maintainable, because this was an individual. This is a REET petition filed before the learned single judge, not a public interest litigation, my lord, for scrutinizing the entire selection process. But when these REET petitions became futile or infractious as of the date of the filing of the REET petition itself.
Because by that time, the time had expired.
By that time, everything has gone.
Yes.
And this issue was not considered by the learned single judge. But today, unfortunately, we didn't get any opportunity to file affidavit before the learned single judge. We approached the Honorable Supreme Court. We had to approach the Honorable Supreme Court. We are not added parties. Now, this 139, most probably petitioner. These 139 persons had no locus in 2022. This was filed most probably in September. The learned single judge was also aware. In another similar writ petitions, what the learned single judge said, that you came now after 7 years. So this writ petition is not maintainable. Same learned single judge, but I have given the copy. I'm just reading. I'm giving the Pore Dibi Dara. This is order dated 3rd of April 2023. The petitioner is Shorodindu Panda. I have got this writ petition. The judge was learned Vijay Gangopadhyay.
3rd of April.
3rd of April 2023. When this
Where do we find that?
My lord, may I just hand over a compilation? I'll not travel with any. Only one judgment I'll be show. Only two, three orders. The first page itself, my lord. I'll be very precise. I'll try to complete it by. I'll show that there are paragraphs also.
ওই যে এইটা একটা বান্ডিল হবে, এটার মতো আরেকটা ওই এর যেটা ওই
First page. This writ petitioner was untrained.
Yes.
Same learned single judge, he was hearing, probably some special interest was showed, my lord, don't take me amiss, my lord, I am bound. Because the learned single judge, my lord, sometimes, my lord, when one is...
Let us not talk.
I'm not. Don't, my lord, with utmost respect, but I think, my lord, there was something. Second paragraph, your lordship has seen, as the application has been filed after 7 years, from the date of interview, I do not entertain the writ petition and same is dismissed. Now, again, your lordship kindly come back to the writ petition.
Here the judgment was on 24th of
April 2023. Impugned judgment. 3rd April 2023. Impugned. It is on 12th of May 2023. In this matter, the impugned judgment was delivered on 12th of May. At that time, this matter was hard. Your lordship had seen, my learned friend Obroto Spudar has shown all the orders passed at different occasions.
Yes.
So when this matter, the learned judge was conscious that this writ petition could not be entertained, but for this special writ petition. And today, because of his endeavor, now we are fighting the case for these 32,000 jobless persons. And now because of the SSC, they are afraid.
Board also did not show these materials. Your argument could have been more substantial if you had shown that board placed this order before my lord.
My lord,
board also did not.
My lord, they had the obligations to make us party. They did not make us party.
Board also didn't say this fact which you are arguing.
Yeah.
So let us not go into those issues.
No question of board showing. But board failed. Board, he was represented by some advocate. Malad, he might have failed. But if any one of these selected appointees, if they were made parties,
so
they could have brought it to the notice of the court.
Who was appearing for the board.
He failed. Malad, but this was the same learned judge. Yes, I would have appreciated that it was passed by a different learned judge. It was by the same learned judge. Now kindly again come back to the writ petitions, my lord. Paragraph 10.
Yes, para 10.
Your petition states that after notification, the procedure was started for appointment from October to December 2016.
Yes.
The interview and verification process started on 31st of January 2017. Even at that time also, they did not raise objection. We could not have started this process. 31st March 2016 was the last date. Now they participated. Allegedly, the result was declared, but there was no panel, there was no merit list, there was no category-wise merit list, no division of numbers, rank was given to anyone. In website of the board, there was dedicated space where a person could see whether he or she was impaneled or not. Mark it, my lord, because everyone can see. I have got the screenshot of the website. Then the full merit. I don't mind, my lord, what is merit list and panel, what they meant to say, my lord. No merit list was ever published in spite of repeated requests. The full merit list was not made to public. Allegedly, it was stated on 31st January, allegedly stated on 30th January 2017. List of 10 candidates were published. My lord, full stop. My lord, there was a full stop. Kindly take it, my lord. This allegedly it was stated on 30th January 2017, list of trained candidates were published. Paragraph 10, page 39. This is for trained candidates. Kindly mark this, my lord. This allegedly word was issued. It was stated on the list of trained candidates were published. This is meant for trained candidates. This allegedly. They may say that we have stated allegedly, but they have used this word allegedly for trained candidates.
So list of trained and untrained were separate?
Separate. That is
in
the
all
next.
The districts. In all the districts.
On district, they did themselves have stated on the same line on 4th.
So how this list of trained was published by PK?
They themselves have said on the DPSC board.
Yes.
Published dictionary meaning your lawsuit is not make known to third party.
Yes.
Now that was as per rule. Now then on the same line, my lord, page 39, kindly take, my lord, how they have stated and how the learned judge proceeds. My lord, on 4th February 2017, that is after the stop. On 4th February 2017, list of non-trained candidates other than Bengali medium was published. This is their case, it is not my case. I did not, my lord, elaborate anything because that was the case made out before the learned single judge.
And
the panel was published.
8th February?
On 8th February, list of non-trained candidates and candidates from Bengali. Now, other than Bengali medium on 4th and 8th of February, for Bengali medium were published. That is their own statement. On oath. And it has been affirmed as true to their knowledge. Page 45 is there.
Yes.
Page 50, kindly take this, their affirmations. It was affirmed as true to their knowledge.
Yes, which paragraph you want to show next?
My lord, next is 11.
Yes.
Now, may I just my lord, continue these paragraphs? It was published on 4th of a list of 8th. From the dates and the list, it is clear that all trained candidates of TET 2014 were appointed through the first list, and after completion of the same, as per notification dated 2nd March, to the board appointed non-trained candidates. So they were also aware of the appointment of non-trained candidates. That is more evident from the 11. Your petitioner states that on 23rd, now they are trying to explain the delay or something like. Your petitioner states that on 23rd December 2020, 15 February 2021, 17 February 2000, notices were published for recruitment as assistant teacher in private skill from TET 2014. The board has appointed non-trained teachers after 2016. even and intentionally ignore the petitioner by giving excuses of notification issued by MHRD by such and such. Again, I am saying that was the case made out that after 31st March 2016, no appointment. Thousands of non-trained students were appointed and petitioners, though similarly placed, were ignored. If it is stated, if it is a stand of the board that no non-trained candidates can be appointed, then all appointments of non-trained candidates made after March 2016 are bad in law.
What did they mean by that? If it is the
They
standard,
said that after March 2016, no non-trained candidate could have been appointed because the MHID notification, that is the cut-off date. But the board had given appointment to the non-trained candidates beyond 31st March, so they should be given appointment.
where is that notification
Yes,
of August
yes,
2017?
Compilation
Page?
My lord, I have given another compilation, that is list of events. Kindly take, I'll not show any, all documents have been given, including the learned judge, the order of the Honorable Justice Kandan extending that, my lord, selection. Straight away come to, my lord.
Kandan's order is page 63.
Baba, stop debo. Has you lost, you got it? Page? Page is, the page, kindly take 103.
No, Mr. Bandyopadhyay, even if this point is not taken, suppose extension, assumingly it was till 31st of March 2016.
Even then the writ was not maintainable. That is why I am saying.
Let us 31st March 2016 was the date for completion of that qualification. Relaxation given up to 30. Now the employment recruitment rule was of 2nd March 2016. So this point, I don't know what they will be arguing. Is it their case that since the relaxation period has expired, no appointment could have been made of untrained candidates?
Again, come back to page paragraph 11.
No, this is one aspect of the matter. And the other is, suppose you do not consider August 2016. If we take, extension was up to 31st. Since the selection process commenced prior, recruitment rules were framed prior to that. Then whether this relaxation will still apply after the board has published commenced the selection process?
Yes, because this is the mandatory qualifications, my lord, as per under the Right to Education Act.
That is why 3-2 proviso was given, that once you are appointed, you can complete this.
See, my lord,
I think I'm not clear to you.
So far as the untrained candidates is concerned, there was a time period given under that particular notification. Your lordship, kindly first take that first notification.
Page, that is page 95.
MHID.
MHID.
Yes, that your lordship has got it. Now kindly take one judgment. Not judgment. This is sequence. This was sequence of event.
Page 63.
Page 63. Kindly take page 63. By that time, no extension came. 14th of September 2016. Page 63.
Yes, what is this?
Kindly state the operating portions. I am not. But Mr. Shubhi Sharnal was appearing at that time.
No, this extension was given by the court.
Yes, by the court till the extension is obtained from the central government, from the ministry. Kindly take page. 73. Kindly come to page 73.
Yes.
Bottom. It will make the position clear. From the above deliberations, the views of the court are as follows. May I?
Yes.
The state government sought relaxations from the second respondent herein, namely the Ministry of Human Resource Development and the School Education Literacy Department under the provisions of Section 23(2) of the Right of Children to Free and Compulsory Education Act 2009. The rules framed thereunder in order to fill up the entire vacancies with the untrained candidates, since there are no adequately trained candidates who are presently available. The 6th respondent had granted relaxations after certain conditions. Similarly, the trained and untrained candidates shall be appointed to the available vacancies, as the trained candidates will not be prejudiced in any manner. The state government took the stand in order to provide proper educations to the students who are in poor need of the same in the entire state. Education is a fundamental right to the state. The learned Additional Advocate General rightly pointed out that approximately 40,000 vacancies are available as of now. The 6th respondent's condition that the state government is to first absorb and appoint the trained candidates and thereafter appoint the untrained candidates. The trained candidates, as per the statistics by the learned Additional Advocate General, are about 19,495. Therefore, the untrained candidates' appointments will not be disturbed with the trained candidates. All the respondents are strictly to follow the logical use as per provisions of Section 23(2) of the Right to Chair. The notification dated 1st of April 2015 granted an extension of the relaxation up to 31st of March 2016. But due to the General State Assembly elections, the appointment process has been kept in abeyance. As such, there is no lack of service on the side of the state government of West Bengal. Therefore, this court permits the respondent number 1, 2, 3 to proceed in the mode of selection for appointment of teachers. Further, respondents are liberty to approach the respondent number 4, 5, and 6 in order to extend the relaxation.
Where is that 4th August? Up to
Yes,
August.
now that August you will also file 103, page 103.
Page 103.
Is it legible, Malad?
Even then we have to read. Yes, page 103.
Yes, it is of National Council of Teacher Education, Malad, notification dated 22nd September 2017. This notification was not there, Malad, in the first compilation placed by our senior friend Mr. Kullan Bandobadhyay.
No, this is of NCT.
NCT, Malad, I am coming, Malad. This is
Page 95 is of Ministry of Human Resource Development.
Yes,
Extension.
no, Malad, both, Malad.
MHRD.
Yes, MHID and Malad. Under the same, I will show the relevant portion.
Central government has to relax, na? Not NCT.
Under the specific Malad, provisions of the Right to Children and Free Education Act, this notification was also issued.
Kindly come to page 95. This is of central government did have the authority in consultation with the council, maybe. Page 95 of Priyanka.
The MHID notification. Yes, kindly
Has
take.
there been any MHRD notification?
Yes, Malad, that has been referred to in this. Malad, that is why. And whereas, Malad, last and whereas, in view of the above mentioned directions of the Ministry of Human Resource Development under Section 29 of the NCT Act, and after considering the recommendations of the expert committee chairperson in NCT in exercise of his power under clause 12 of the NCT recognition of norms and procedural regulation 2014, granted relaxation by the NCT headquarters such and such, and later to the following provisions in the NCT regulations 2014 for ensuring that the directives of the MHRD for implementing the amendment to RTE Act 2009 are duly fulfilled. Then, Malad, kindly skip this 1 to 4.
Yes.
Then, Malad, next page 104. This 104. And whereas, Malad, I'm just skipping the first part. And whereas, after having considered all the above facts and figures, the NRC considered the case in its 275, decided that the recognitions be granted to the National Institute of Open Schooling for DLED against scheme. Malad, that is for the DLED training. That is meant for training to the untrained candidate. Next page, 105. serial number, my lord, 18.
18. Yes, read that this program shall.
This program shall only be for those in service, untrained teachers in the private unaided schools appointed on or before government aided and private unaided schools appointed on or before 10th of August 2017.
This program, that is program is pertaining to
DLED,
DLED,
that is the training qualifications. That is to be obtained by the all teachers, as per all untrained teachers. NCT regulations, the DLED to be obtained, and in fact, the 2024 judgments cited most probably by Pratik Dhar, that refers to this. So up to 10th of August, there was no other relaxation. After 10th of August, there was no scope of appointing any untrained candidates, and no appointment in the present case has been made after 10th of August.
Yes.
That is the cutoff date. So now they were aware, they didn't say it because they said that 31st March 2016 is the cutoff date. Even then, on their own pleading, the REET was not maintainable in 2022 because no appointment could be made. Because there is no negative equality, that one wrong has been committed, so they should be given the. Just come back to page 104. One explanation probably that may confuse your lordship subsequently. That is why. Page 104, serial number 4. After the whereas, serial number 4. Just mark it, my lord. NIOS shall operate study centers manned by staff by academy as per instructions of NHJ to enable NIOS to complete the training of in-service untrained teachers numbering out 11 lakhs by 31st of March 2019 all over India. And that is why this 18 months, instead of 2 years, that was relaxed, reduced to 18 months, which have been subsequently approved by the Honorable Supreme Court in 2024 judgment. May I clear? Because requirement was 2 years. Because of this decision that one must have this training by 31st March of 2019. Now 10th August was the cutoff date, so they are not getting this 24 months. They were only getting 18 months of training. So for those teachers, it was relaxed. And ultimately, which has been approved by the Honorable Supreme Court, relied upon by Mr. Pratik Dhar repeatedly. Page 104.
Yes.
Now kindly again come back to page 39 of the paper book, paragraph 11 I have made. That is their case after March 2016, the appointments are bad in law. How could you file these petitions in September 2022? You are asking to be further wrong to be committed. It was your belief. Now what they are shifting. This was their individual case. They say now what legal right they had on that date.
Yes.
This is a fundamental of mandamus, that one has to have some either fundamental right or legal right breached. What legal right they had in September 2022? After 31st March 2016, when they are themselves, their cases after 31st March 2016, no appointment. Have you approached the court before 31st March 2016?
Yes. Anything else, Mr. Bandyopadhyay?
Yes, my lord, I'll be only limiting my argument on the writ petitions. I'll not travel beyond. I'll show another thing, my lord. My lord, why they have shifted now their case to make it as a public interest litigations, and landless single judge readily accepted this. My lord, page 40, paragraph 12. Now they are shifting to scam. Page 12, paragraph 40.
Yes.
Your petition states that recently the TET 2000 busted in West Bengal from several cases lodged by CBI and from several orders passed by the Honorable Court. The petitioners came to note that several illegal appointments have been given by depriving the petitioners. I don't know on what basis they are stating, because TET was not challenged. TET is qualifying examination, just like JEE. TET 2014 was a qualifying examination. They did not challenge that qualification. On the other hand, their cases all are TET qualified. They are saying that they are TET qualified, but they were shifting because these allegations of scam related to TET 2014. TET 2014 has not been under challenge. Then they are shifting to the 2020 also recruitment process to make it
Yes.
Then page 40, now they are trying to shift it, to 2020 selection process. Non-trained candidates are the worst sufferers of this scam. They are not challenging my appointment. They said non-trained candidates are the worst sufferer of this scam. Now on 23rd December 2020, the West Bengal Primary Education published one notification for recruitment of 16,500 primary teachers. And in that publication, they have stated candidates whose qualifications as per guidelines of NCT. Such notification is absolutely illegal, as qualifications should be measured as on the date of qualifying TET. Every 3 lines has some different meanings. This is for 2020 selection process. In 2020 recruitment process, the state government or the primary the board had no authority to say any non-trained candidates has the opportunity to apply, because by that time long back cutoff date has expired. Now only trained candidates could be appointed. Now what their case? Since I am qualified in 2014, so I should be given chance to participate in 2020 selection process.
Yes.
Then the next. Now, as per the actions, after 4 lines, you'll see has got it the same paragraphs. As per the action, now the scam. As per the action of the board and as per different statements given by the then president of the board, Mr. Manik Bhattacharya, all trained candidates were recruited. As per notification of the board, the petitioner should get fair chance to the recruitment, but the board has done a complete injustice to them. If it is the stand of the board that non-trained candidates cannot be appointed, then all appointments post March 2016 are bad in law. You will say, put in the question, is it their case that after 2016 no appointment? That was their case. Board should apply some theory to everyone, and board cannot simply pick and choose between the candidates. The petitioners are TET 2014 candidates, and they deserve the same relaxations which was granted to the other non-TET candidates. But where is the case that no aptitude test was taken, the selection process was vitiated, the interview was vitiated, there was no guidelines framed? Where is this case in the writ petition? The learned single judge with utmost respect took the responsibility of making the writ petitions better for the benefit of the writ petitioners. Where is this case? Next para, page 1.
You can skip that para. You can skip that para.
14. Yes, though, no, why?
Now they say they are
I'm not reading it. I'm saying these were all trained candidates which numbers were given, roll numbers.
Yes.
Then, my lord, এক সেকেন্ড দাদা আমার মতন পড়তে আমিও দাগ মেরেছি প্লিজ paragraph 14 please I'll show that sorry
No, you have reached up to page 41, paragraph
13. 13 I just yes
you one line you have missed, fourth line. It is there also there.
There was huge illegality in the whole selection procedure of TET 2014. This is TET 2014 was not selection procedure. This was qualifying examination.
2014 was an illegal TET which was they are saying, but they participated
on the basis of their TET qualification in the
Yes.
selection process.
Yes.
Yes. They are not challenging this state. I'll be only.
So they on one hand say that we are TET qualified.
As I said, there was a scam in TET.
No, the state is bad.
Bad. Now I'm further going, my lord. Paragraph 14.
We have been taken through this. We have gone through this.
No, my lord, I'll show, my lord. I'll not show entire paragraphs. I'll just show only three paragraphs, my lord. 14. Your petitioner stated at present there is more than 1 lakh vacancy in the education department of West Bengal. Since 2011, several examinations conducted to fill up the vacancies, but a single recruitment procedure could not be completed without corruption and irregularity. That's fake. They did not contemporarily challenge anything. They said every selection procedure was marred by corruptions.
Yes. Yes.
Next, 15. Your petitioner further states that on 30th April 2022, their cause of action starts from 30th April 2022. They could have applied before the court only up to 10th August. 30th, Srimati Mahua Mitra, Honorable Member of Parliament, Krishnanagar Lok Sabha, made a statement before the media pointing irregularities in TET panel. There was no TET panel. TET is qualifying examination, whereas to secure minimum marks to qualify. The recently person lodged a complaint against one MLA of one political party. MLA took crores of money from George Westman with a promise to give them job in the schools, and in that case, personal assistant of Tapos Saha MLA, Theotta was arrested. The statement of Mahua Mitra described the situation prevailing in the state of West Bengal. No complaint was annexed, no statement was annexed, no particulars have been given there. Then, my lord, I just keeping, my lord, since you are now 18 is the most relevant paragraph. I'm skipping the other portion, how they have made out their cases. Then again, my lord, paragraph 17, one line.
Read the first line of para 17.
Yes, that is why I'm reading. Your petitioner states TET 2014 is the biggest scam of the education department.
But they had been successful.
They had been successful, but they are challenging the recruitment procedure initiated in September 2016 by which we got appointment.
Yes.
They did not challenge because TET 14 was not under the in the prayer. They didn't challenge it. They challenged nothing.
They challenged through their averments. TET is where.
Yes, that is permissible, most probably.
Yes.
Well, 18 is my last paragraph. I will be.
Yes.
Your petitioner states that the board has stated in different cases filed before this court. They are so vigilant. They did not approach, but they are vigilant. Your petitioner says the board has stated in different cases filed before this court that 42897 candidates were selected till date, but no merit list of such and such was ever published. As pausing my moment, but how they could know in different cases what board has pleaded? They could have approached earlier. This was candidates was ever published. By the board should be directed to publish the merit list by disclosing the numbers obtained in written interview and reservation category wise list should be published. Candidates were informed through SMS and no merit list of candidates was published. It proves that the mischief in the recruitment process. If the process was free from all corruption, then they ought to have been transferred merit list of TET 2014 qualified candidates. What they are actually contending, panel in the recruitment process or TET qualification. Again, it is not clear. So these are all vague allegations.
Yes, yes.
Now, the process was not, this is the last 5 lines. The process was not completed in February 2017. And the department is well aware of the same. And this honorable court should take notice of the same. Persons who did not qualify for TET 2014 were appointed as primary teachers by the board in spite of specific case steps were not taken, and shows there was corruption and illegal financial transactions while conducting the recruitment process. Not a single instance, not a single particulars, wild allegations. The writ petition should have been dismissed with exemplary cause.
Yes.
Then,
yes.
My lord, one should, my lord, if your lordship don't take me amiss, this writ petition was used for, my lord, some political gains at the cost of livelihood of 32,000 teachers. Not only their livelihood, their family members' livelihood, only for the purpose of their, only for the purpose of satisfying some vested interest, which has nothing to do with this recruitment process.
All right. Yes.
Now, next. While conducting the recruitment process, the department ought to have taken suo motu steps, but that was not done for reasons best known to them. Moreover, many candidates complained that TET 2014 qualified certificates were not issued to them. And even today, they are fighting for that. There is no delay in filing public interest litigation as the corruption is still continuing. Now, what is the cause of actions? Corruption or this recruitment process? I'm just putting a question to myself.
Yes. Yes.
Still continuing, an honorable single bench of this honorable court also passed several orders regarding TET 2014 even in September 2022. So that's why they come in September 2022 file, and they were probably my lord, most my lord, they believed in their heart that their petitions will not be thrown away.
Yes.
Now the grounds. Next page, page 45.
Yes.
Round 3. Page 45.
Yes.
No, there's some limit in copy paste. I'll show. For that, the department has recruited non-trained candidates after expiry of the relaxation given by NCTA, but not recruiting the petitioners. Now, after relaxation given by the NCTE, the relaxation was given up to 10th of August 2017. Because other relaxation was MHRD. So they were aware that relaxation was given up to 10th of August 2017. Otherwise, they could not have referred NCTE.
NCT was a party. NCT was a party. Yes.
Next. 5. Kindly mark these grounds are interesting. For that, board has committed fraud upon non-trained candidates and did not follow their own notifications. Equal rights, board has not. Now, there is not a single ground about TAT. But the pleading state.
Yes.
Prayer, page 48, prayer 4 is their prayer into September 2022. Now, your lordship was to consider whether this prayer was maintainable in September 2022. Forgetting the delay. This was their virtually main prayer.
Yes.
So my first point is this petitions was not maintainable, forgetting everything. Because the 10th August 2017 was cut-off date. According to the petitioner, 31st March 2016 was the cut-off date. No appointment could have given, so they could not have maintained any writ in 2022, seeking appointment as untrained candidates.
Thank you, Mr. Honorable.
And this is not maintainable. Now, delay, my lord, I had shown that my learned senior friend, Mr. Kishore Datta, had also given judgments. My lord, in my compilations, I have annexed 2 judgments, my lord. I'll just refer it. And the delay, your lordship is aware that even the Supreme Court had held in several cases that even if you allege violation of fundamental right, I have read the entire writ petition. There was no allegations of violation of any fundamental right. At least they did not allege that Article 16 has been violated. Not a single pleading.
Yes.
So even for violation of fundamental right, the Supreme Court has held that it could be general period of limitations prescribed on the Limitations Act for suit. 3 years. But there are other judgments of the Honorable Supreme Court which relaxed. That is for public interest litigations. And for pension holder and land acquisition cases. For long delay in getting compensation. Only those cases. But not in any other cases. This writ petition is for mandamus. Alleging, probably they did not allege, but I assume that there was an allegation of infringement of their legal right. There is no such allegations that what has been violated, what right they have got under what provisions of law, and that has been infringed. That is no such allegations.
Yes, which judgments you are relying upon, Mr. Bondukar?
The other issue, only one fact, I'd like to drop, since because they are seeking, one has achieved something in SSC, so they will be seeking the same thing, the corruptions. Now the facts and figures I just mentioned for your noting, I have the document, but I do not wish to, second, there was investigation ordered in a PIL. CBI and ED both my lord, conducted investigations. All the untrained candidates were given an appointment. Trained candidates, they were called. My lord, 2076 candidates, my lord, their appointments were doubted. And final list.
Pertaining to which selection process?
In 2016 selection process.
2076
candidates. That was the primary first list which was prepared.
2076.
Only 2076. All are trained.
Yes. Then what happened?
And that was shortlisted. One by Justice Abhijit Ganguly, coming for terminating service of 269 trained candidates through board. The board was directed to terminate the service. Board terminated 269 candidates. The another was of 94 candidates. That is also for trained.
Terminated out of 2076. This is a 2016 process.
2016 process.
So the trained candidates, out of them, board was directed to cancel
269. আমি সব বলছি please.
269.
269. That
was not challenged by the.
Yes, this is now stayed by the Honorable Supreme Court.
In a separate litigation.
Separate, absolutely separate litigations. Not here. This is trained.
Pertaining to the trained.
Trained.
But 2016.
2016. Well, that whatever I gathered. Then out of these, another order, that was service of Justice Amrita Sinha, 94 candidates are directed to be terminated.
Out again, of that 2076.
2069. 2069. 269, sorry, 269.
2076, you said?
2076 is the least prepared. Out of that, 269 it was terminated. Then 94 terminated, directed to be terminated.
So this is also pending before Supreme
Court. Those persons are still working, but all these, my lord, for trained. Not a single untrained candidate was listed by either by the CBI or by ED. Because why I am telling so, the entire allegations of the ED against Manik Sarkar, Manik Bhattacharya, was regarding this admission in the DLA training. They mainly, predominantly, those are the allegations. That he had taken some commissions from the training colleges. Those are the predominantly allegations both before the CBI and before the ED. And ED shortlisted only 5 candidates. I'm giving these numbers from CBI and ED, both investigation. But ED allegation said only 5 candidates that too trained, their appointment was under scanner.
Yes.
But there is no allegations so far as the untrained candidates are concerned. And all untrained candidates, they were called by the CBI, their documents were verified by the CBI, and none of them has been listed in this 2076 number of candidates.
2076 is for the trained.
That is why, but CBI has conducted investigation already.
Ultimately, the number of trained candidates appointment was more than 10,000.
12,000 around.
42,000 was the
11,000 and odd. Out of that,
076 came from which?
11,000 and odd.
So it is the same selection process.
Same selection process. What I am telling,
not trained and untrained, the procedure in the manner in which the selection process was conducted. Naturally, you are coming within that.
No. What I am saying,
076, you are harping on trained and untrained. We are not saying that. Both trained and untrained were pertaining to the.
No, I am saying for the CBI had carried out the verification process.
Yes, that we understand.
For untrained, for untrained and also trained. That is why I am saying that for trained and untrained, both. And CBI found that not a single candidate who was untrained, their appointment is, any doubt can be expressed.
What, CBI filed the charge sheet?
No, CBI filed a report before this court.
Charge sheet already filed.
Charge sheet.
That is the Somen Nundi Ramesh Malik matter, third supplementary charge sheet already filed by the CBI. In this selection, two investigation is going on. I will apprise this court, madam.
10 candidates, and I am told
original OMR sheet one.
As per today, there is no allegation against the board. So all the charge sheet filed. No allegation.
And those who are not in a 2018 process.
All right.
Now, another, my lord, those are now pending before the Honorable Supreme Court. Nothing to do with these smaller untrained candidates. Nothing to do. They're separate proceedings.
The process was the same, in which 2076.
No, different process.
How divided? 2016 recruitment process. Mr. Bandyopadhyay, 2016 is the one selection process.
Initiation of selection
Let us
process.
understand. We are hearing argument on pertaining to 2016 selection process. And
No, your lordship is also hearing the argument of 2014 TATE because those are the basis of the TATE petition.
TATE 2014 as well as selection process 2016. Now in 2016 selection process, which was also marked through academic mark, TATE, interview and aptitude, both the trained and untrained were evaluated on the basis of that.
No, the separate panels.
Panel may be separate. The procedure was the same. It is inex. We will listen to him. We are asking you today.
Those who are not TATE qualified, those are found.
Mr. Let me a chance. We have not asked for clarification from you. Please wait. Yes, Mr.
Yes, let me finish, my lord. But very easy for you to jump up, my lord, to rob livelihood of everybody when the writ petitions has no life.
Yes.
My lord, I have prepared a compilation. So far as the delay, my lord.
Yes, we have got it.
So far as I will not read, my lord, I am just pointing out the judgments.
Yes.
My lord, 1969, volume 1 SCC, page 110. Paragraphs, my lord, para 18, 39 and 40 is for the Honorable Justice Sikri.
18,
39 and 40.
Yes.
And the Honorable Justice Bachwat, my lord, passed a separate judgment, my lord, for him, my lord, paragraph 65 and 66. On the same line.
This is on delay.
Delay when there is when there is an allegations of violation of fundamental rights, the court cannot stretch.
Yes.
Then, my lord, 2024, volume 3 SCC, page 148. Paragraph, you will also kindly note the paragraphs only.
Yes.
Paragraph 15, 19.1 and 19.6. The next judgment, my lord, roving inquiry. This is the Supreme Court, my lord, very specific. My lord, paragraph 25, that is 2009 5 SCC, page 641. As my learned friend Obrotos has submitted that in a writ proceedings of judicial procedure, no question of roving inquiry. The court cannot. Paragraph 25, my lord. Citation.
Yes.
শেষ করে দিই আর ফালতু।
Yes, any other judgment?
My lord, so far as the Sadanand Hello, kindly note some paragraph because all paragraphs have not been read. I'm just making the paragraph.
That is 2008.
Yes, 84 SCC.
Yes.
Paragraph 58, 59 and 63. Now, why I'm saying so? You also will not find a contemporaneous letter, objections or document challenging the selection procedure.
First letter was 2020.
2020. No letter. The first writ petition is 2022. There's not a single demand justice.
Thank you, Mr. Bandyopadhyay.
Now, another judgment, I'll be just showing it. That is last judgment. I'm only giving reference. But for your lordship, smaller, I'm not reading. The last judgment, that is.
Don't say that the judge didn't hear you. I have personally, both of us, both of us, we had determined that we shall.
এত বড় সাহস হয়নি I don't have the courage. But
2006
2006-11 SCC, I don't know whether this is not in my compilation, but it has been attached in your lordship's judgment. Well, this is
no, today's P56. No.
SCC, page 356. This relates to the recruitment process of judicial service and executive officers of Punjab, Haryana, where the chairman of selection, the Public Service Commission was arrested. In a allegations was there was the bribery for the job. This was the allegations of the basis. Now the state government, there was inquiry initiated because since judicial officers appointment was also involved, the High Court constituted a committee and made an inquiry. On the basis of recommendations of the High Court, services of all were terminated by the state government. That is under challenge before the Honorable Supreme Court. The Supreme Court said, in gist, I'll giving the paragraphs, it says that you cannot do so because each of candidates, there is no evidence, there was no evidence that for each of
the money.
Yes, all the candidates, their selections was bad because otherwise the selection process was followed as per the rules. There was no allegations that the persons of the interview board, there was no allegations against them.
There is no allegation here also.
Here also. That is why now ultimately since there was an inquiry report, Supreme Court segregated some and remanded back before the High Court to verify again that you cannot by sweeping. Now why I am saying so, since just now your lordship says that trained candidate but the frame selection process. Now that verification has been done. They have been segregated. 269 and 94 have been directed to be terminated, which have been stayed in a separate proceeding. But there is nothing found so far as the trained candidates. The Honorable Supreme untrained candidates. So that cannot be paragraph facts. So far as the facts are concerned, paragraphs 2, 3, then paragraph 8, para 19, 20, paragraph 25A, paragraph 41, 66. 71, 19, 94, and last is 145.
71,
90, 94, and 145. First three judgments, I need not, your lordship, you can see it. Why I have relied upon? It is consistent, that in a futile rate, no order is generally passed by the High Court. This writ was futile as on 2022. It was infructuous. It was not a public interest litigation. Not this division bench is hearing a public interest litigation or assumes a jurisdiction of a court of public interest, hearing public interest litigation. The mandamus appeal. That's all, my lord. I'm extremely grateful, my lord. I'll take 1 minute. But I found a notification in the website of the board. That is regarding interview in respect of 4 districts. Four districts. Districts are Coach Bihar, Howrah, Purbo Midnapur, and Bardwan. Kindly take the next page, copy forwarded to the chairman.
Where do you have?
I am giving it. Just yesterday, if not in compilation. Website of the board available. It is still now available in the website of the board. Now kindly take the next page.
You have no copy?
I am just getting it from here.
We will share. You take this copy.
No, I'll take it from here, my lord. Yes.
Just tell us.
My lord, kindly take the next page. This is for the my lord, fixing date for interview for different districts of Kojibihar, Howrah, Purbo Medapur, Bardwan, and what are to be what documents to be brought by the candidates. Then next page, copy to chairman, interview board and district inspector school PE of 4 districts, namely Kojibihar, Howrah, Purbo Medapur, Bardwan, for making arrangements for smooth conduct of vivacy interview and aptitude test and scrutiny verifications of the testimony test in accordance with the guidelines enclosed herewith. And the recruitment rules. Well, I didn't find the guidelines in the website, but it was enclosed in these documents that I wanted to show. The guidelines to be provided by
Guidelines have not been framed, they say.
it was enclosed. Kindly take this was enclosed.
Yes, my lord.
It was there.
My lord, your lordship, when asked me, my lord, I told your lordship, my lord, when we
That
get
14.5 rules.
4.5, my lord,
4.5.
is there your lordship specific question was?
Modalities, guidelines.
Modalities, there was any guideline for conducting the interview or? My lord, we said, my lord, my lord said submitted.
That you have prepared.
It was
Guidelines have
forwarded
been
to them.
prepared. Those guidelines were there.
Was there to the interviewers how to conduct the interview, what should be the.
Where is that, Mr.?
My lord, we have ready, but since your lordship, my lord, said that I will hear you at that. That is why you have not handed over.
Showed that it was.
Then when your lordship asked, my lord, I will hand over.
What is this tester? Oh, in accordance with the guidelines of the 2016 exam.
No, guidelines enclosed herewith, and also in terms of the West Bengal section, now enclosure as stated. I show that this enclosure was there when this was forwarded to the relevant respective district primary school council.
Oh dear, this is 2016 itself.
Yes. This is Malad in respect of our
you are
interview.
showing for the reason that there were guidelines. This you are showing for the reason that guidelines were
Was
framed.
there for interview.
Who else is Mr. Sen and anybody else?
Mr. Shane Millard is there, Mr. Lahiri and Millard after that.
Very good. So Mr. Sen and yourself are the remaining 2 persons.
Mr. Lahiri Millard is there, and Millard kindly Millard also tolerate me Millard for some time.
Mr. Banerjee, we request you, please, you do your homework. Which argument you want to say, which has not been advanced? Already, as we have calculated, more than 38 judgments have already been referred before
I will
us.
not Millard trouble your lordship with any new judgment. With any new judgment.
The
Millard, kindly
repetition
allow me,
means
Millard, half an hour time any day that
we are allowing everybody. It is not that we are not allowing.
Kindly do not Millard all
We
that
are not being able to.
3031.
Mr. Sen, how long will you be taking?
PPE stock 2013. It is still available. 5th December 2016.
কি ফিক্স করলাম না